past that before the chapel on the left-hand side is the bathrooms. If you want the cafeteria, you go to the left and that direction. And then also we've muted for those people on the line, we've muted all calls that are coming in, so you'll need to send a message via the chat function if you have any questions during the presentation, and we'll make sure to get those to Kim or the other presenters. And am I missing anything?
Well, let's see. So you mentioned about questions. If there's technical difficulties, check in with you.
Yeah, send a message via the chat function as well, please.
I think that's it.
Fantastic. All yours.
All right. Welcome to all of you who are present. Can you guys hear me too? Okay. All right. Hopefully I won't shout too much. Really appreciate all of you being here. I think this is our 3rd or 4th year doing this. It's always great to see you guys show up here live. In addition to you guys who are here, we have about 200 people who are off-site listening to this remotely at areas all across the Intermountain West. So if there are questions as we go along, feel free to ask those questions, but I'll probably have to repeat those so that the people off-site can get those. I think we're going to try to do something a little bit different this year. So instead of asking questions as we go along during the presentation, at the end of each section I'll stop and I'll ask for questions. That might make it a little bit easier for those people who are listening off-site. Also, just as a full disclaimer, we are recording this, and so if you do ask questions, make sure that you don't do anything that's going to be self-incriminating, okay? With that said, let's go ahead and talk. These are the things we're going to talk about today. We're going to talk about the fraud and abuse stuff. In February, we met, and that's when we talked more about the patient rights stuff, the HIPAA issues, consent issues, discrimination issues, those types of things. For those of you who missed that or have nothing better to do this weekend, you can go on, and those are at our website, and you can get the download for those things, and you can listen to those. I'll be talking about the fraud and abuse laws, take about an hour. Then I'll apply those fraud and abuse laws to common situations. We'll then take a break, and then my good friend Teresa Sorelli from the Idaho Medical Association will talk about some of the common billing and coding problems. Teresa's the person I call when I have coding and billing issues. After that, I'll talk about what you do if you think that you have a compliance issue based on the things that we talked about. And then my partner from Salt Lake, Corey, who's an expert on antitrust stuff, will come in and wrap us up talking about the antitrust issues. As far as written materials, we provided you a whole bunch of stuff electronically because we are green people, I guess. So hopefully you've got access to that. You should have gotten the links to all of that information. So if you didn't, by all means let us know and we'll make sure that you get that. Among other things, you've got copies of the slides, the OIG compliance program guidance for physician practices and for hospitals, some OIG publications, including the self-disclosure protocols, and a whole bunch of articles that I've written over the past time. Okay, so that's kind of the preliminary issues. Let's go ahead and we'll start talking about the fraud and abuse laws. So I'm going to cover the statutes, applying the statutes to common situations. A comment on this, though. I'm going to talk in this meeting mainly about the federal law, which applies to all of us. That's the ones we've really got to be concerned about because of those doggone feds. But I'm also going to talk about Idaho law. For those of you who are listening who may be in other states, remember that you need to make sure that you check your own states. State laws are fairly common on these types of issues, especially when it comes to the anti-kickback statute and the like, but you want to make sure that you're aware of what occurs in your own state with your own state law. So just remember that. A little bit of background. Government is the biggest payer of health care in the United States. Okay, it is huge. You know, trillions of dollars that they spend in health care. Well, the government is concerned about running out of money, and therefore they are actively seeking to get some of that money back in the case of fraud and abuse. The publication that they just issued said that in 2017, they recovered $2.6 billion in fraud and abuse. Now, that's just a drop in the Medicare bucket, but if you're one of those people that had to pay several $1 million back to the government, that is a big ticket item. Now, the government is actively doing this because it's a money-making thing for them, right? For every $1 that they spend in fraud and abuse efforts, they recover $4. That's actually down from prior years where they were recovering as much as $7. You know, everything's not as efficient these days, I guess. But what does that tell you? the government has every incentive to continue to go after fraud and abuse issues because that's how they make money on doing that type of stuff. You can just look at some of the recent multi-million-dollar decisions that have come out, some of those penalties, anywhere from $513 million all the way down to, tens of thousands of dollars. To make matters worse, of course, you have to not only wait for the government to come in there and find you, but you've got an affirmative obligation to narc on yourself under the Affordable Care Act's report and repay rule, and also under state law requirements that you can't just sit back and wait for the government to find you. You have an affirmative obligation to self-report. So we'll talk about that a little bit later. So what are the main laws that we're concerned about? Well, we've got the False Claims Act, the Anti-Kickback Statute, the Ethics in Physician Referrals Act, or STARK, the Civil Monetary Penalties Law, and along the way we'll talk about some of the Idaho laws. First and foremost is the False Claims Act. This is the government's main weapon for coming after you in order to get money back. The False Claims Act is very broad. It says you cannot knowingly submit a false claim for payment to the federal government. Pretty basic, right? But it also says in the wake of the Affordable Care Act that if you have received or submitted a false claim and received money improperly, then you've got this affirmative obligation to report and repay any overpayment that you've received, any amount that you've received improperly, within roughly 60 days for most of you. What are the penalties if you fail to do that? Well, at the very least, you're going to have to do a repayment back to the government plus interest. In addition, the government can recover a civil monetary penalty. It used to be $5,500 to $11,000. They recently upped that because of a cost of living modifier. So now the penalty is civil monetary penalty of $11,000 to $22,000 per claim that's submitted. Now that's not per kind of practice. That's per claim that you submitted to the government. So those penalties can add up awfully fast. In addition to that, you can get hit up with treble damages, and you can be excluded from Medicare or Medicaid, which, like we'll talk about a little bit later, if that happens, that's kind of the death knell for practicing in the healthcare field these days. In addition to all of that, you can be hit up for qui tam lawsuits. Qui tam lawsuits are basically situations where private individuals can go ahead and sue you for a violation of the False Claims Act on behalf of the government. And then if they recover, they get a percentage of that recovery. So they're kind of like bounty hunters. Well, that creates an incentive for these people to go out and sue you, report these violations, and bring these lawsuits against you. So you got to not only be worried about the government, but you got to be concerned about others who might come after you for that. It could be maybe a competitor. It could be, well, I got a call last week from back east where a former employee who was let go was a little bit upset that they were let go, and therefore they looked around and decided that there was a false claim, so they called me to find out whether or not they had a qui tam action against their health care provider, against their former employer. So you've got to be concerned about those situations. Those penalties in that False Claims Act can add up awfully quickly. A good example is the recent Toomey case out of South Carolina. This was a situation where the hospital entered into a bunch of part-time employment agreements with these specialists who were making a lot of referrals to the hospital. They were 10-year part-time employment agreements. They thought that they structured it to comply with STARK and the Anti-Kickback Statute, but the government came in there and looked and said, no, when you look at the overall structure of these things, it really is commercially unreasonable, and therefore it violated STARK. As a result, the penalties under STARK, like we talk about, is that they can't bill the government for those referrals that were made from those physicians, okay? So they went back and looked over the referrals that those physicians had made over the relevant time period, $39 million that the government had paid pursuant to these improper referrals. So they have to do the repayment of the $39 million, but that's not enough. Under the Civil Monetary Penalties Law, the government can also recover treble damages, so that raises the total to $117 million. In addition, those people had submitted 21,000 claims based on those improper referrals, so you get hit up with the penalty of $5,500 per claim. That raises an additional $119 million. The grand total, $237 million, because they failed to have in place appropriate contracts with their referring providers. Now, it ultimately settled for a measly $72 million, and out of that relator, the person who brought that qui tam lawsuit, they received $18 million of that. So if you're looking to fund your retirement, I guess you go to work for a hospital and look for false claims along the way. The bottom line there is you have to take that stuff very seriously because of the penalties that can add up very, very quickly. Now, none of you are going to go back to the office and say, well, let's come up with a scheme to submit false claims. But, you know, false claims can arise in situations where you may not normally consider it. Well, certainly, if you're submitting claims for services that were not provided or were different than were claimed, including using the wrong CPT codes or something like that, then that can be a false claim. That's pretty clear. But it can also, the government has said, if you're submitting a claim for services that did not comply with the applicable standard of care, well, when you're submitting that claim to the government, you're representing it as medically necessary services, that the services you provided were consistent with the standard of care, and therefore if you're violating the standard of care, if it's not up to the required quality, then hey, guess what? You've submitted a false claim to the government, okay? And that hasn't occurred all that often. The ones that we're most concerned about, I think, are the situations where you fail to comply with the conditions of payment or other fraud and abuse laws, because when you submit that claim to the government, you are impliedly representing that you have complied with all of the relevant laws. Therefore, if you violated STARC or the Anti-Kickback or any of those conditions of payment that appear in the Medicare provider manual or those types of things, then that is, the government said that that could be a false claim and it could result in that false claim repayment, okay? So that is the Federal False Claims Act. It is scary stuff, okay? In addition to that, you've got to look at your state statute. Idaho has its own version of the False Claims Act. Under the Idaho statute, you cannot knowingly submit a claim that is incorrect, make a false statement in any document that you submit to Medicaid for payment. You cannot submit a claim for medically unnecessary service or fail repeatedly or substantially to comply with any Department of Health and Welfare rules concerning Medicaid. Now, that's problematic because, you know, you got to stay on top of those Medicaid rules, because if you fail to comply with that, then that could give rise to a false claim. Under the Idaho statute, you'd have an obligation to report and repay. And by the way, if that was paid by Medicaid, Medicaid's a federal government, so it could also result in claims under the Federal False Claims Act. The statute also says, the Idaho statute says that if you breach your provider agreement, that can give rise to a false claim and a repayment obligation. How many of you have gone back and looked at your provider agreement lately? You ought to do that. I think in the materials we provided, you've given me a copy of the sample Medicaid provider agreement, but there's a lot of requirements that are there that you need to make sure that you comply with. And finally, just like the Federal Act, if you fail to repay any amounts that are improperly received, that in and of itself can then result in penalties. What are the penalties under the state law? Exclusion from state health care programs like Medicaid. A lot of you think that might be good to be excluded from Medicaid. You could also get civil monetary penalties up to $1,000 per violation. There's kind of adjustments there that can come up or down. You can also get referred to the Medicaid fraud unit, and they can go after you for criminal violations of those things. All right, that is the False Claims Act. Any questions about the False Claims Act? All right, moving right along, the next one is the Anti-Kickback Statute. The Anti-Kickback Statute says that you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by a government program unless the transaction is structured to fit within one of the regulatory safe harbors. Now, let's talk a little bit about that. First of all, who does that apply to? Who may be subject to a violation of the Anti-Kickback Statute? Anybody. It's not just the physicians. It can be anybody. It could be the marketing person. It could be the manager of a practice. It could be a healthcare provider. Okay, so it applies to anyone. Now, note that it only applies if you knowingly and willfully offer. It's an intent-based statute, so you have to have improper intent. A couple of comments about that. The first is, intent is not the same as necessarily knowing you did something wrong. This just says you have to knowingly and willfully offer, pay, solicit. It's not that you have to know that you're violating the law. So even though you thought what you were doing was okay, because it's okay in every other industry in the world, just not healthcare. Ignorance of the law is no excuse, okay? Also, it's an intent-based statute. It has to be knowingly and willfully. You have to knowingly and willfully make that offer, okay? But the standard for determining whether or not it's knowingly and willfully is pretty doggone low. The test under the Grieber case is what's called the one-purpose test. That says that the anti-kickback statute applies if one purpose of paying that remuneration is to induce or reward referrals, then it's a violation unless you've structured it to fit within the regulatory safe harbor. It doesn't matter whether you've got 99 legitimate reasons for what you're doing. If one purpose is to induce improper referrals, then it's a violation of the anti-kickback statute. Now, if you're up there on the stand and the government's going after you, how difficult is it for you to establish that, no, the fact that this guy was a very major referral source had nothing to do with the fact that we gave them a free car for Christmas or something like that. It's kind of hard to prove that negative intent, so the cards are stacked against you, okay? Next comment, what does it apply to? It applies to remuneration. What's remuneration? Essentially, it's anything of value. Could be money, could be other stuff. We'll talk about that more in a minute, okay? What are the penalties if you violate the anti-kickback statute? Hey, you go to jail for this one, guys. This is a federal felony. So you can get up to 5 years in prison, a $25,000 criminal fine. In addition, you can get hit up with civil monetary penalties under the civil monetary penalties law. It used to be $50,000 per violation. They actually updated that, and I failed to include the updated numbers in that. In addition, you can get hit up with treble damages, and it's automatic exclusion from Medicare or Medicaid, which means that you can no longer basically participate or be employed by any entity that takes Medicare or Medicaid. Okay, pretty draconian penalties. Now, if that's not bad enough, in the Affordable Care Act, they made a violation of the anti-kickback statute also a violation of the False Claims Act. Well, what does that mean? Well, that means, in order to establish the criminal penalties, what's the standard of proof? For those of you guys who watched the OJ miniseries, standard of proof in a criminal case is beyond a reasonable doubt, right? On the other hand, in a civil case, if the government wants to come after you in a civil case, what is that? Preponderance of the evidence. It's easier for the government to prove to come after you. So it makes it easier for the government to come after you for an anti-kickback violation. So if it's an automatic violation of the False Claims Act, what does that mean? That means all of those penalties that we talked about under the False Claims Act, they can also go after you for a violation of the anti-kickback statute, including allowing key TAM relators to come after you for an anti-kickback violation. If you do a self-report, you realize, oh my goodness, we made this payment when we shouldn't have, or we structured a deal and it didn't fit within one of the safe harbors. We've got to self-report to the government. The government has said that the minimum settlement that they will accept for under the OIG self-disclosure protocol for an anti-kickback violation is $50,000. So you gave away that wrong pen to that referral source. Guess what? $50,000 fine. That's an expensive pen, okay? When it comes to the anti-kickback statute, the key here is that any time you want to do any kind of deal with a referral source, or you get anything from somebody to whom you are referring business, you've got to be concerned about the anti-kickback statute. It's kind of like danger, Will Robinson, danger, Will Robinson. You've got to be aware of the potential penalties that can rain down upon your head. Now, as I mentioned, the anti-kickback statute applies to any form of remuneration to induce or reward referrals for federal program business. It could be paying them money, certainly, but it could also be offering free or discounted items or services, offering some kind of perks or gifts, maybe giving free space, allowing referring providers to use free space or free equipment without charging them, offering meals, offering insurance, to cover their insurance, giving them trips, paying for their CME. Anything of value could be remuneration. It could be overpayments or underpayments, anything that's not fair market value. So you go ahead and contract with this referring provider to provide services, but you're just going to pay them more than fair market value. Well, what's that more than fair market value? The government would say that means payments in order to induce referrals. Or maybe you are going to provide services to another entity, you're going to receive it, or maybe if you receive less than fair market value. Maybe you've got an entity that you want to make referrals to, you're willing to charge them less than fair market value for services that you're providing. Well, that difference is presumably remuneration for referrals. It could be payments for items or services that are not provided. Maybe you're paying somebody to serve as a medical director, but you look back at the records of what this guy really did over the past 3 years as medical director, and they did nothing other than played a lot of golf, okay? In that situation, then you could be hit up for violations there. Could be payments for items or services that are not necessary. well, we're smart people. We'll just hire that guy as a medical director even though we don't need it. We'll require them to do something, but this is a way to funnel more money. No. If it's not necessary services, if it's not commercially reasonable, then, hey, that's a violation also. It could be professional courtesy, waivers of co-pays or deductibles, low-interest loans or subsidies, business opportunities that are otherwise not commercially reasonable. Bottom line is anything of value, anything else of value that you're giving to potential referral sources or receiving from entities that want to receive your referrals, that could trigger the anti-kickback statute. Now, because it is so incredibly broad, the government has come up with safe harbors. If you structure your deal to fit within one of these regulatory safe harbors, you are, no surprise, you are safe. Okay? But you don't have to fit within the safe harbor. It's not required that you fit within the safe harbor. It just means if you don't, you're not safe. And then the test is one purpose of what you did to generate improper referrals, which is kind of a hard test to satisfy. Okay? In order to fit within those safe harbors, you got to comply with all the requirements of the safe harbor to be technically safe. You mess up on one requirement, then you're not safe. But the more you put in place, the closer you come to the safe harbor, the safer you're going to be. Some of those safe harbors, there's a whole bunch of them under 42 CFR 1001.952, including safe harbors that apply to bona fide employment contracts, personal services contracts, leases, investments, transportation programs, blah, 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 blah. Lots and lots of different safe harbors. For each one of those safe harbors, they all have a number of technical requirements you have to comply with. So if you want to do a deal with a potential referral source, and it's a referral source for Medicare or Medicaid services or other items or services payable by federal health care programs, you want to make sure that you structure that deal to fit within one of these safe harbors. If you don't, you're at risk, okay? Well, what about if it is only a pen? Well, there is no de minimis exception under the anti-kickback statute. It's not like it says, well, if it's over, you know, you can do gifts for less than $100 and there's no problem. There is no de minimis exception under the anti-kickback statute. But let's face it, the government has more important things to do than to go after you for a pen. So anything more than a nominal value, there's some commentary from the OIG that says if you give anything more than nominal value, they really don't define nominal value in the case of the anti-kickback statute, so you got to be careful. Well, what about if we just pay fair market value, even if the stuff's not needed? Well, again, that simply because it's a fair market value payment doesn't necessarily protect you. They've said that a fair market value payment does not legitimize a payment if there is an illegal purpose, okay? So you can't fit within the safe harbor. You decide to pay fair market value anyway, that's not going to protect you if you're still paying that in order for a legal purpose to generate or reward referrals. But again, if you're paying fair market value for services you really need, you're going to be safer. Not absolutely safe, but you're going to be safer. Finally, if you can't fit within the safe harbor, consider the risk of program fraud and abuse. If you structure the deal to fit within or have certain safeguards in place so the government's really not harmed, maybe you're giving notice, maybe you're not requiring referrals, you're doing these other things that maybe the government has identified in advisory opinions, as long as you put these these safeguards in place and there's no risk of program fraud and abuse, then you may be okay too. But again, you're not going to be absolutely safe. The government has issued a bunch of advisory opinions. If you want to do a deal and you want to know whether or not the government's going to come after you, you can petition the government for an advisory opinion. You submit the facts to the government, pay them some money, wait for 6 months to never, and you get some kind of a report back that'll tell you whether or not it's thumbs up or thumbs down. Now, those advisory opinions are all published, but the advisory opinions are only binding on the parties to the opinion. But if you structure your deal to consistent with an advisory opinion, a favorable advisory opinion, chances are the government's not going to go after you, no guarantees, but you're probably going to be safer. If you want to do a deal and see if the government has done an advisory opinion, you can go to the OIG's website, you can search for prior advisory opinions. Those are all published out there. Okay, that is the federal anti-kickback statute. Very broad, scary statute. Okay, any questions about that before we move on? Okay, talk about the Idaho anti-kickback statute. A lot of you didn't know that Idaho has its own anti-kickback statute. The Idaho statute was actually put in place by insurance companies, okay? This was put in place, and a lot of it was geared towards these glass repair places. You know, you've seen those ads, right? Come to us, and we will repair your your glass, and we will only bill your insurance company, won't charge you, we will waive your copay and deductible, and we'll also give you a meal at, Mikasa or whatever it is, right? Well, what are they doing? They're offering kickbacks in order to get your business. And the private insurers in Idaho, they said, we don't like that, and therefore we're going to put in place this anti-kickback statute. That anti-kickback statute not only applies to those automobile glass repair places, it also applies to healthcare providers. So a service provider, including providers of healthcare services, cannot pay another person, or another person cannot accept payment for a referral. What's that? The anti-kickback statute. You cannot provide services knowing the claimant was referred in exchange for such a payment. So even if you're a provider, you didn't offer that payment, but you know that you were referred based on that payment, then you can't provide the service knowing that the claimant was referred in exchange for the payment. And you can't engage in a regular practice of waiving, rebating, giving, or paying the claimant's deductible or health insurance. If you do that, then you can get hit up with a fine under the Idaho's Department of Insurance statute of $5,000 per violation. Now, as far as I know, the Idaho anti-kickback statute has never been enforced. I'm not aware of anybody who's gotten fined by a violation of the Idaho anti-kickback. In fact, kind of a funny story, I was talking with the former director of insurance a little while ago at a program, and I mentioned the Idaho anti-kickback statute and asked for their position. He didn't even know there was an Idaho anti-kickback statute. But his attorney does. I did talk to the attorney. Okay. In addition to that, some states, most states, I think perhaps all states, also have fee-splitting statutes. They normally appear in the relevant Medical Practices Act or Podiatry Practices Act or Chiropractic Practices Act or Dental Practices Act, which basically prohibits licensees from splitting fees or paying other people in exchange for referrals. Okay? So you can't do that under the licensing statute. What happens if you violate that? Well, they can come after you for unprofessional conduct or take away your license and maybe impose some civil penalties there. In addition, under the Idaho statute, you cannot give or receive or aid or abet the giving or receiving of rebates either directly or indirectly. Okay? Those can be interpreted to apply to kickback situations. All right, that's the Idaho anti-kickback statute. Let's talk about the federal Stark Law. You wonder how they got the name Stark? Where did that come from? Well, it comes from Representative Pete Stark, who was the bill sponsor. To understand Stark, it really helps to understand kind of the background, why it came to be. Back in the late 1980s, the government had switched, its payment program, right? And it was kind of ratcheting down on the payments that were going to be made to healthcare providers. And as a result of that, healthcare providers were out there looking for other sources of revenue. What did they do? They started opening up their own labs or their own imaging centers and things like that. The government suddenly noticed that they were receiving more and more claims for MRIs and for lab work. And they were saying, why are we getting so many more claims? And they look at it and they say, well, these physicians now have an ownership interest in these entities. They have a vested interest in sending the patients for this work because they get some of the money from that, right? The government and Representative Stark said, well, we can do something about that. So they came up with the Stark Law. It says that if a physician or their family member, it applies to physicians or family members, has a financial relationship with an entity, another entity, that physician may not refer patients to that entity for certain designated health services that are payable by Medicare or Medicaid. Okay? So if they got the financial relationship, they can't make referrals to that other entity for these certain services. In addition, if they do make an improper referral, that other entity can't bill the government for those services that were improperly referred, unless you structure the deal to fit within a regulatory exception. Okay? Now, Stark doesn't prohibit the financial relationship. You can own that MRI center. You just can't make referrals to it, unless you've structured the deal to fit within one of the regulatory safe harbors. That is Stark. What happens if you violate Stark? Well, at the very least, you can't get paid for services that were improperly referred. If you did get improperly paid, then you've got to do a repayment back to the federal government within 60 days. If you fail to do that, then you can get hit up with civil penalties. Originally, it was $15,000 per claim submitted, or $100,000 if you're trying to do some kind of circumvention scheme. Those penalties have also increased, and I forgot to include the increased penalties. In addition, if you've got a Stark Law violation, chances are you've also got an anti-kickback violation. Okay? If You've got an Anti-Kickback violation, criminal penalties, False Claims Act violations. In addition, if you're violating Stark, you've also got a False Claims Act problem, because when you're submitting those claims to the government, you're certifying to the government that you're in compliance with applicable laws, including Stark. So if you've got a Stark law violation, it's not only got to be concerned about Stark, but you've also got to be concerned about the False Claims Act and all those other penalties, just like the people at Toomey found out. Okay? Now, another consequence of the Stark, if you do have a Stark law violation, you've got an improper referral or financial relationship that has not been structured to fit within one of the regulatory safe harbors. Stark says that you cannot bill or receive payment for the services for the prohibited referrals during that period of disallowance. That period of disallowance is basically the time period that you've got this non-compliant relationship going on. So if you've got a non-compliant relationship, fine, you can have the non-compliant relationship, you just can't make referrals over to that entity, and you can't get paid for any services if you do make an improper referral. So those claims are disallowed. Now that period of disallowance begins from the time that you're non-compliant, but it doesn't end just when you bring it back into compliance. That period of disallowance continues until any amounts that were improperly paid or overpaid, maybe you've been paying that cardiologist in excess of fair market value because they bring in a lot of work for the hospital, that period of disallowance continues not only till you bring the contract back into compliance, but you also get repaid any overpayments that you made to that cardiologist. And it's always really easy to go back and get that money from the cardiologist, right? They're happy to give you back their money. Okay? So you've got to be careful about structuring those deals. Prospective compliance alone does not end the period of noncompliance or correct it. You've got to go back or end the noncompliance. You've got to go back and recapture those repayments. So with Stark, any financial relationship or item of value between a physician or their family member, so it would also apply to, for example, contracts between the hospital and the brother or the wife or the spouse of the physician. Any financial relationship or item of value between the physician or their family member and an entity providing designated health services, it triggers Stark. So if you've got that situation, you need to be aware of the Stark concerns. You've really got to be concerned about it too, because in the wake of the government's recent enforcement activities, the government's not only going after the entity that received the payment improperly, they're also going after individuals who are involved. So for example, in that Toomey case, that involved Stark law violations. The CEO from Toomey had to pay $1 million of his own money in order to repay those violations. All right, so let's talk a little bit more about Stark, about the application. Remember the Anti-Kickback statute, who does it apply to? Anti-Kickback, who does it apply to? Anybody, okay? Anybody. Physicians, marketing people, whatever. It applies to anybody. Stark only applies to financial relationships with physicians or physician family members. Physicians are MDs, DOs, oral surgeons, dentists, podiatrists, optometrists, and chiropractors. So if you want to set up a deal with PAs or NPs, well, you may have anti-kickback issues, but you generally don't have Stark issues. Okay? It also applies to relationships with the family members of physicians, who are family members, who are spouse, parent, or child, sibling, step-parent, stepchild, step-sibling, grandparent, grandchild, or in-laws. Okay? It's really easy sometimes. You're always thinking about, especially if you're with the hospital, you think about the relationships with the physicians, but you may not always think that, hey, we've got a financial relationship with a spouse or a child or somebody like that. Those financial relationships with those people, those contracts or that, they have to be structured to fit within the safe harbor or else you're going to violate Stark. Now, Stark applies to referrals by the physician to entities with which the physician or their family member has a financial relationship. Financial relationship is very broad. It can be a direct relationship, it could be an indirect relationship. So you don't directly have the financial relationship with that physician, but you have a contract with this company, and that company is then in turn owned by the physician. Well, that's an indirect financial relationship, and therefore you would have to structure your deal to fit within Stark. That financial relationship could be an ownership or investment interest, so maybe that physician is a member of an LLC with which you've got a contract. They might be a shareholder in an entity. So it could be, there could be a partnership, whatever. It could also be a compensation arrangement. Compensation arrangement is, again, pretty much anything of value. It could be money, a contract. It could also be giving them freebies. It could be offering them supplements or subsidies, anything of value. Now, Stark, again, doesn't prohibit financial relationships. It just says if you've got a financial relationship, you can't make referrals unless you structure the deal within a regulatory safe harbor. Referral is very broad. It's any time the physician is ordering services or certifying that the services need to be done, plans of care that are signed off by the physician. Anytime the physician is basically saying, hey, you need to get this service from this person, then that can be a referral. It applies to not only referrals outside the organization, but it also applies to referrals within the group. So when you've got a physician who's referring to a tech or to another physician or a nurse practitioner in your practice, that is a referral. Does that physician have a financial relationship with that person? Sure they do. That means Stark applies even to those intra-group referrals. So you'd want to make sure that you've structured your arrangement to fit within a Stark safe harbor. Now, Stark does not apply to services that the physician personally performs. If the physician's personally performing it, he's not referring it, right? He's doing it himself. So you can structure deals where you compensate the physician based on the services that the physician personally performs. That's generally not going to implicate Stark. But if you're compensating the physician based on his referrals to others at your organization, that is going to implicate Stark, and you need to structure it appropriately. Stark also generally doesn't apply to services that are performed by radiologists, or at least traditional radiologists, not interventional radiologists. That's because radiologists generally don't generate referrals, they just receive referrals. Same thing with pathologists. Now, Anti-Kickback Statute, it applies to referrals for items or services. What items or services? Items or services are payable by any federal health care program, right? Medicare, Medicaid, TRICARE, whatever, okay? Stark only applies to certain designated health services, not all health services that are payable by government programs, but only certain designated health services that are payable by Medicare or, in the wake of subsequent amendments, Medicaid, okay? That includes inpatient and outpatient hospital services, outpatient prescription drugs, clinical labs, physical, occupational, or speech therapy, home health services, radiology and certain imaging services, radiation therapy and supplies, DME and supplies, parenteral and enteral nutrients, equipment and supplies, and prosthetics and orthotics. Okay? If it's not on that list, then Stark's not going to be implicated. You probably all have an anti-kickback concern, but at least you don't have to worry about Stark. Okay? Now, CMS maintains a website where they list the CPT codes that are implicated by Stark. Now, that list is not exhaustive. It's possible that there are other CPT codes that are affected by Stark that are not on that list, but if you want to know whether or not a particular CPT code is affected by Stark, you can go to that list. If it's there, you know it's implicated. If it's not there, it doesn't necessarily mean it's not, but it at least gives you some guidance. Now, Stark does contain a number of safe harbors. Some of those safe harbors are applicable to both ownership and investment interests. Some only apply to investment interests. Some only apply to compensation arrangements. There is no liability under Stark if you comply with all of the requirements under the safe harbor. But in order to get the protection, you've got to comply with all of the requirements. Remember I said that the anti-kickback statute is intent-based. It's not necessary to comply with the safe harbor. Stark is different. Stark's what we call a strict liability statute. That means intent is irrelevant. It doesn't matter whether you didn't intend to comply or not comply. It doesn't matter whether or not you satisfied 9 of the 10 elements. You either comply or you don't comply. And you've got to comply with all of the requirements in order to fit within one of those safe harbors. If you don't comply with all of the elements, then chances are, if there have been improper referrals, you're going to have to do a report and repayment. And you only need one to fit within one safe harbor. It's possible that some transaction may implicate several different safe harbors, but you only have to fit within one in order to protect it. But you have to make sure that each financial relationship fits within the safe harbor. And some deals may involve multiple financial relationships. So you need to make sure that you look at each one of those financial relationships and make sure that they fit within Stark. So what are some of the exceptions? Well, Stark has exceptions for, again, both ownership and compensation. The ones that are most important for you are probably those that deal with group practices. Stark applies to referrals within the group practice, but there are safe harbors that as long as you've structured your deal to qualify as a group practice under Stark, and there's a bunch of things that you need to do to qualify as a group practice under Stark. If it's a group practice meeting those requirements under Stark, then the in-office ancillary services exception allows you to make referrals to others in your group to provide services, ancillary services, as long as it's within your office, but there's certain requirements that have to be satisfied. Similarly, that group practice exception allows you to make referrals to other persons within the group so long as those services are provided under the supervision of a physician within the group. Okay? Those are the most important ones. So those are the ones that most of you who represent physicians in group practices, those are the ones that are going to allow you to make referrals within your organization. But you need to make sure that your group qualifies as a group practice, including your group compensation structure, and that you otherwise fit within those safe harbors. There are certain Stark exceptions that apply to ownership interests or only ownership interests. The most important one here is rural providers. If you're a rural provider, including Idaho and a lot of our clients out there in the hinterlands and the Intermountain West, then Stark gives you a lot of leeway. The general rule is that Stark would apply if you're a physician in a metropolitan statistical area, so that if that physician has an ownership interest in this other entity, that physician can't be making referrals over to that other entity for designated health services, including like MRIs or labs or those types of things. Rural providers, though, they get a special exception. The theory there is that, hey, if we're out in the rural area, physicians are probably the only ones who are going to invest in and bring in those services like the MRI. So we need to allow physicians to make those referrals to that other entity so that we can get those services out in the hinterlands. So if you are in a rural area, which is defined as outside a metropolitan statistical area, and you're providing 75% of your services to patients in that rural area, then Stark will allow you to have an ownership interest in this other entity. That is a huge one for Idaho and other areas that have large rural populations. The ones that we deal with most often are the Stark exceptions that apply to compensation arrangements. These are the exceptions that would apply to, for example, employment arrangements, independent contractor or services arrangements, space or equipment rentals, timeshare arrangements, recruitment benefits that you're going to offer, physician retention, and so forth, okay? The key there is if you want to do this relationship with this physician, you need to make sure that you crack the books and take a look at the Stark rules and make sure that you structure that deal to fit within one of those regulatory safe harbors. So here's a quick cheat sheet for Stark analysis. So to know whether or not Stark applies or whether or not you've got a problem, you've got to ask yourself these questions. Is there a financial relationship between the DHS provider and the physician or a member of the physician's family? Remember, it can be a direct or indirect relationship. It could be an ownership or investment interest. It could be a compensation arrangement, which is any remuneration, not just the payment of money, anything of value. So do you have a financial relationship between the DHS provider and that physician? If they do, then you got to think, Stark. Then you ask the question, does the physician make or has she made referrals to the entity for DHS that's payable by Medicare or Medicaid? Remember, Stark doesn't prohibit the relationship. It just says if they do have the relationship, that entity can't make, that physician can't make referrals to you, and you can't bill for it, okay? If they do, if there is a referral relationship going on, you got to ask yourself, well, was it structured or is it going to be structured to fit within one of those regulatory safe harbors? If it hasn't, then the question is, oh, dang, okay? Have we billed for United or services pursuant to one of those improper referrals? If you do, then you probably got a repayment obligation back to the federal government. The government maintains a website dealing with Stark. On that website, it will have a few advisory opinions. There's not nearly as many advisory opinions for Stark as there is for the Anti-Kickback statute, but you can go there. There's some FAQs. It has that list of designated health services that are listed by CPT codes so that you can figure out whether or not it's DHS is implicated, and other stuff. Okay, that is Stark in a nutshell. Any questions about Stark before we move on to the civil monetary penalties law? You guys are out there, right? Your eyes are open. Okay. Oh, Teresa, question. Okay, so the question is, yeah, so the question is within health systems, like, are you talking about like hospital systems or, yeah, like a hospital that shall remain nameless, referring to other employees of that entity referring back. Yeah, does that implicate self-referral laws? That could be either the Anti-Kickback statute or START. Does it implicate it? Sure it does, but there's exceptions that if, for example, the bona fide employment exception. So if these are employees, then a health system, a hospital, can generally require their employees to make referrals to others within the organization. In 42 CFR 401.354 subsection D4, it basically says that you can require employees and contractors to make referrals subject to certain exceptions, okay? So yeah, that's what it does. Same thing, it may be independent contractors, not just employees, it could be independent contractors. If you've got the independent contractor relationship, assuming that you've structured that independent contractor relationship appropriately, you can require referrals within the organization. Yeah, another question. Excuse me. Okay, so the question is, how does this apply to pharmacists who can, at least in Idaho, they've given them some management over healthcare. Well, pharmacists wouldn't be covered by START, so you don't have to worry about that. Pharmacists would be covered by the Anti-Kickback statute if and to the extent that that pharmacy is making or receiving referrals for items or services that are paid by federal healthcare programs. So if you have, for example, some kind of a financial relationship between a referring provider and the pharmacy, or the pharmacy is paying a provider to make referrals or doing their prescribing to that pharmacy, then they could have problems. They would need to make sure that they structure that relationship to fit within the Anti-Kickback statute. Also, if the relationship is with a physician, they would have START issues because the physician is covered by START. So. All right, another question.
You mentioned the breach of provider agreement.
Mm-hmm.
What are some common errors these people make?
So I mentioned earlier under the Idaho statute, under the False Claims statute, it says that you can be liable for repayments if you breach the Medicaid provider agreement. So the provider agreement, if you haven't read it lately, it's pretty broad, and it prohibits you from submitting claims like for medically unnecessary services or services that don't meet the quality of care, or services that don't comply with the Medicaid manual. So, and in addition to the basic terms, in some provider agreements, for some types of providers, they have additional requirements. So if you're breaching any of those types of things and submitting claims to Idaho Medicaid, then you could have a repayment obligation under the Idaho statute and potentially under the federal statute. All right. We will move on and talk about the Civil Monetary Penalties Law. Again, this is another federal statute. This is kind of a catch-all statute. This prohibits a laundry list of specified conduct. A lot of the stuff we've already covered. It's the one that allows the government to impose civil penalties for things like fraudulent billing, false claims, failing to repay, violating EMTALA, failing to grant timely access. If the government shows up and wants to look at your records, you can get hit up with civil penalties if you don't make your records available to them. The ones that I wanted to talk about specifically, though, are the Civil Monetary Penalties Law, among others, prohibits you from offering inducements to program beneficiaries, offering inducements to physicians to limit services, and submitting claims for services ordered by or contracting with an excluded entity. What happens if you violate the civil monetary penalties? The penalty depends upon the specific misconduct, but anywhere from $2,000 to $100,000 in fines. Again, that's been adjusted upward recently. Treble damages, denial of payments, you can get excluded from Medicare or Medicaid. They can come in and take away your firstborn child. Actually, they can't take the firstborn child. There are CMPL violations may also result in False Claims Act violations, could result in anti-kickback violations, and START violations if it involves physicians or their family members. So let's talk about some of those. The most important one for purposes of you guys is probably this. The Civil Monetary Penalties Law says that you cannot offer or transfer remuneration to Medicare or state program beneficiaries, your Medicare patients, right, or Medicaid patients, if you know or should know that the remuneration is likely to influence the beneficiaries to order or receive the items or services payable by federal or state programs from a particular provider. What does that mean? You can't offer freebies or incentives to your patients to get them to come to you, okay? If you do that, that can be a violation of the, if they're Medicaid, Medicare beneficiaries, that can be a violation of the civil monetary penalties law. Also a violation of the anti-kickback statute, right? Because the beneficiaries can make referrals of themselves or others to you, so it could violate the anti-kickback statute too. What's the penalty? Well, the base is $10,000 for each item or service. Again, that's been adjusted upward recently. Treble damages, repayment of the amounts claimed, exclusion from Medicare and Medicaid, and you also likely have a violation of the anti-kickback statute, which of course is a felony and an automatic violation of the False Claims Act. So basically all that stuff can rain down upon your head. Well, what does this mean? Well, it applies to remuneration. What is remuneration? Remuneration is basically, again, anything of value. If you're offering anything of value to your Medicare or Medicaid patients in order to get them to come to you, this inducement to get them to come to you, then that is a potential violation. The statute specifically defines remuneration to include items or services for free or less than fair market value, unless you satisfy certain conditions, or waivers of co-pays and deductibles, unless you satisfy certain conditions. So waiving co-pays and deductibles is a violation of the civil monetary penalties law. If it's co-pays and deductibles for Medicare and Medicaid beneficiaries, unless you satisfy certain criteria. Now, that definition of remuneration in the statute excludes certain things, okay? It excludes waivers or co-pays based on financial need or after a failed collection efforts, if certain conditions are satisfied. If you do that, then it's outside the definition of remuneration, so it doesn't trigger the statute. Certain items or services if there's financial need and certain other conditions are met. Incentives to promote delivery of preventative care if certain conditions are met. Payments meeting the anti-kickback statute, safe harbor. Retailer coupons or any other remuneration that promotes access to care and poses a low risk of harm to patients in federal health care programs. That's kind of your catch-all, okay? So if you can fit within these definitions, you're excluded from remuneration, so the civil monetary penalties law doesn't apply. Okay? We'll talk more about applying that in a little bit. Okay, next one I wanted to cover was this only applies to hospitals or critical access hospitals, not everybody else. But for hospitals or critical access hospitals, the civil monetary penalties law says that you cannot knowingly make a payment directly or indirectly to a physician as an inducement to reduce or limit medically necessary services provided to Medicare and Medicaid beneficiaries who are under the direct care of the physician. And you're thinking, well, wait a minute. Isn't that what the Affordable Care Act's all about, the Medicare Shared Savings Program? We're trying to pay you to reduce those services, right? Well, it helps to kind of understand a little bit about the background here. This law came out, this particular section came out when the government shifted from, paying hospitals basically on a strict fee for service for a DRG payment, the prospective payment service, right? So now under the prospective payment service, theoretically, the hospital gets X dollars for this diagnostic code, no matter how many services they provide. Well, the government was concerned that, well, now the hospitals have an incentive to reduce the services. Mom really doesn't need those pain meds, right? Well, because of that, the government says, well, let's put in place this statute that prohibits the hospitals from offering incentives to physicians to reduce those services. Okay, that's the background for it. Now, this statute used to be applied broadly to cover all sorts of, what are called gain sharing arrangements, where you go to the physician and say, hey, if you help us save costs, then we will split those gains with you. We'll split those cost savings with you. A year or two ago, the government modified the CMPL statute to make it a little bit easier to do those gain sharing arrangements. They modified it so now it used to be that you couldn't offer an inducement to limit any services, okay? Now it only applies to limit medically necessary services. So it does open it up to potential gain sharing type arrangements as long as they're structured properly. Again, let's go back to the comment though. Well, what about the Medicare Shared Savings Program? Isn't that what this is all about, is providing inducements to limit services? Yeah, it is, but I guess it's okay if the government does it. It's just not okay if you guys do it, okay? There's exceptions under the Medicare Shared Savings Program, exceptions for the civil monetary penalties law that allow you to participate in the Medicare Shared Savings Program. All right, next one, excluded entities. If you violate any of these statutes or other statutes, you can be excluded from participating in Medicare or Medicaid. The statute says, hey, you cannot submit a claim to the government for an item or service that was ordered or provided by an excluded individual. We're not going to pay for it. If that service was ordered by an excluded individual, we're not going to pay for it, with subject to certain limitations for emergency services. Not only that, the government says, hey, and we're going to go a step further. We're not only going to pay, if we refuse to pay, you can't submit a claim that was ordered by an excluded individual. We're not going to pay for that. Not only that, but you can't use any of the money that we are paying you to contract with or pay another entity who has been excluded. So that means that you can't employ any excluded individual in your organization, whether or not they're dealing with clinical services or not. So I've had a couple of situations. For example, there was a healthcare entity that hired a temp person who later they hired him as an employee. They found out that that temp person, years later, was excluded. They had to go back in and repay a whole bunch of the money that they'd received over the years from Medicaid because they had hired this excluded individual. So what are the penalties? Well, again, you can get hit up with $10,000 per item or service that you submit improperly. You can get hit up with trouble damages and repayment of the amounts paid. You can also be excluded from Medicare or Medicaid for hiring somebody. Now, that statute only applies if you knew or should have known of the exclusion. Knowledge is, you just knew that they were excluded and you did it anyway. It could also be that you should have known. How would you should have known? Well, it could be that you received a remittance, explanation benefits back from the government that says, hey, we're not going to pay for this because this person's excluded. It could also be that that person is listed on the government's list of excluded individuals or entities, the LEIE. The LEIE, the government maintains this list of excluded individuals, and you are expected to go out and check that against your employees and your contractors to make sure that they're not on the LEIE. If you fail to do that, if they're listed on that list and you fail to do that, well, you knew or should have known that they were excluded, and therefore the government can come back and get those repayments back against you. How do you check that? Well, the government updates that list monthly. So you can go to the website. You should check that LEIE before hiring or contracting with entities, including employees, significant contractors, vendors, medical staff, et cetera. In addition, you should periodically check that LEIE against your employee list to make sure that they haven't been excluded in the meantime. So you do it when they're hired, but you also do it periodically thereafter. How often do you have to do it? Okay, monthly is the safest thing to do. The government, in some of the supplemental compliance guidance, the government has said, hey, you need to do it initially, and in some commentary they said annually. CMS Medicaid actually issued something and they said that you should be checking monthly, okay? Monthly is safest, okay? You should also condition your contracts and medical staff membership on non-exclusion. So if a person's excluded, it allows you to automatically terminate their contract. So you don't have to worry about now you've got somebody, but you can't get rid of them because you've got a contract with them. If you do find out that a person's excluded, then you need to respond promptly as soon as you receive notice of that person's excluded. Just like the Anti-Kickback Statute, the Office of Inspector General, which is the police for program fraud and abuse, they also issue advisory opinions dealing with the civil monetary penalties law. They're listed on that same website, so if you want to go in and look and see whether or not a particular transaction violates that, you can check those advisory opinions. All right, that is a brief summary of the CMPL rules. Any questions about those? Okay, let's talk about applying some of those rules to common situations. First, let's talk about offering free or discounted items or services to your patients. So your marketing person comes in and says, hey, we need to increase our all the patients that we got, so we want to come up with this really cool thing to offer some kind of free item or service to our patients in order to increase our business. It could be marketing that offers free or discounted items. Hey, come to us and we'll give away free this. Or we're having a sale on our that, or something like that. It could be free items or services, especially when tied to other services that are available by government health care programs. Hey, we're going to do a free screening. Come on in, we'll do the free screening, and you won't have to pay for it, but as part of that screening, we're going to, if something comes back positive, we'll funnel you into the other system and we'll recover the money that way. It's doing the loss leaders. Could be insurance-only billing, which is simply waiving copays and deductibles. Could be writing off bills. Could be refer a friend rewards programs. You've seen that in your dentist's office, right? Could be thank you gifts. Could be drawings, etc. The key there is anything where you're offering something of value, free or discounted items or services to your patients. What are the problems? Well, if those patients are Medicare or Medicaid beneficiaries, then you've got a problem under the Civil Monetary Penalties Law and the Anti-Kickback Statute, maybe the Idaho Anti-Kickback Statute. If that patient happens to be a referring physician, you could have problems under Stark. If you're a 501c3, potential IRS issues. You may have problems with your own insurance contract because some insurance contracts will have provisions in there that prohibit you from offering any kind of inducements. So what are the rules? Well, the rules are generally this. At least under the federal statutes, you may offer free or discounted items to government beneficiaries, your Medicare or Medicaid patients, if the remuneration is not likely to influence the beneficiary to order or receive items or services paid by federal or state health care programs. Because if you can't, if it doesn't induce them, then you don't fit within the statute anyway. That may be difficult to prove, though. More importantly, the government came out and said, well, if it's only a gift of nominal value, we'll let you go ahead and do it. And they defined what nominal value is, so that you can offer an item or service of low value, which is defined as each item or service is less than $15, and the aggregate is less than $75 per patient per year. You can give away the gift card or the gas card or something else as long as each card is not more than $15. And you can only give a maximum of those, a maximum of $75 per patient per year. So I guess you could give them, what, 5? Is that right? 5 of those gift cards per year, okay? So as long as you structure the deal to fit within this, then you should be okay, at least under the Civil Monetary Penalties Law. Now, wait a minute. But that's also an inducement under the Anti-Kickback Statute. The Anti-Kickback Statute doesn't have that additional protection in there. So are you going to get in trouble under the Anti-Kickback Statute? Probably not, because it's the same police who are enforcing both statutes. So I doubt that you're going to get hit up as long as it's you're giving your patients a gift that's less than $15 or the aggregate is less than $75 per patient per year. Next exception, you may offer a free or discount services to government beneficiaries like your Medicare or Medicaid patients if there is financial need. Now, if you're going to do it with financial need, though, you need to justify or you need to document certain things. That there's a good faith determination that the beneficiary has a financial need or after reasonable collection efforts have failed. So they really do have a financial need. You've either documented that they have a financial need, or you tried to collect from them, and you just can't get blood from a turnip. It can't be offered as part of any advertisement or solicitation. So you're not using this as, broadcasting on, Channel 7 or on the FM radio station that, hey, come on down to us. If you got financial need, we'll do all of this stuff, or come down to us and we're only going to charge you, X dollars. You can't do that. It's the key here is to make sure that you're giving it to people with financial need, not using it as a marketing gimmick to increase your business. It can be tied to the provision of other federal program business. We're only going to give you this if you also get these other services from us. And there has to be a reasonable connection between the item or service that you're providing and the medical care of the beneficiary, okay? So as long as the person has financial need, you can satisfy these criteria, then you can stay clear of the Civil Monetary Penalties Law. You may offer free or discounted items to government beneficiaries if you're offering incentives to promote delivery of preventative care, the payments meet another anti-kickback safe harbor, or if there's any other remuneration that promotes access to care and poses a low risk of harm to patients and patients of the federal health care programs. This is kind of a catch-all. Basically, the government says, okay, if you're offering freebies or discounted items, but it doesn't result in any fraud and abuse, it's not going to hurt the government program, then yeah, you can go ahead and do that, at least under the Civil Monetary Penalties Law. The problem is that that's not very well defined. We really don't know what we mean by that. So if you're going to rely on that, you better darn well document that it's not going to result in any federal program fraud and abuse. Okay, let's talk about free tests or screening. I mean, what's wrong with that? We do that all the time, right? hey, come in, we'll provide the free, blood glucose monitoring or doing this other stuff. Well, does that offer something of value? Yeah. Why are you doing it? Well, because you are just good community members. No, you're doing it to get business. That implicates the Anti-Kickback Statute and could be the Civil Monetary Penalties Law. Now, there is no definitive safe harbor that applies to this, but the government in an advisory opinion did say, okay, this was a situation where they were offering free blood pressure checks by the hospital. It went to an advisory opinion. The government said, yeah, we think you can, even though it doesn't fit within a safe harbor, we're not going to come down against the hospital because they have these factors in place. It wasn't conditioned on the use of any items or services from any particular provider. So it's not like we're only going to give you this free blood pressure check if you also get these services from us. The patient was not directed to any particular provider. So if the patient came back in with high blood pressure, oh, here, go see our cardiologist over here, or go see our clinic over there. No, they weren't. They were told that you ought to go see your primary care physician. They weren't directed to any particular provider. The patient was not offered any special discounts or follow-up services. Oh, you got high pressure, blood pressure. Oh, guess what? We're having a special in our clinic over here. If the test showed abnormal results, the visitor is advised to see his or her own healthcare professional. Okay, so if you want to do those free screening type situations, you're probably going to be okay if you incorporate those same types of standards. But the key there is you don't just use that as a loss leader to funnel people into your system, that you send them back to their primary care provider. Now, if they don't have a primary care provider, you could provide a list of other people who could provide their care, but presumably it would include others in the community, not just you. If you're just using you, then again, there's an increased risk, right? Because that suggests that you're doing this in order to get referrals to your program. Well, what about free transportation services? Tell you what, we want to go down and we'll send our bus down to the old folks' home and round them all up and I'll bring them in, okay? Can you do something like that? Well, is that something of nominal value or something of value? Yeah, you're giving them free transportation. So generally you can, it raises possibility of problems under the Civil Monetary Penalties Law as well as the Anti-Kickback Statute, but the government came out with a safe harbor, and they've got new safe harbors issued about a year ago that it's not an anti-kickback violation if it's a local transportation program and you satisfy certain requirements, or if you're offering a shuttle service and it satisfies certain other requirements. You just want to structure your free transportation program to fit within that. Alternatively, you might be able to fit within another exception. For example, if the value of that free transportation is less than $15 per trip, then you might be able to satisfy that other safe harbor that applies to items of nominal value. All right, let's talk about waiving co-pays or deductibles. This is one that comes up quite often. The government says a general rule is you can't waive co-pays or deductibles if it's a government program beneficiary. Why? Why does the government care? I mean, that's just taking money out of your pocket. Government doesn't have to pay the co-pays or deductibles. Why does the government care if you're waiving co-pays or deductibles? They're not losing anything because they didn't get that money anyway. It's you. You're the only one who's losing it. That dang government, they're just interfering again. Why? Why does the government care about waiving co-pays or deductibles? Anybody? Exactly right. It induces patients to come in. Remember, the insurance company and the government puts in place those co-pays or deductibles. Why? Because it creates a disincentive for the patient to come in and makes sure that the patient has a good reason. They're only going to come in if they really need it. Otherwise, they could get up in the morning and say, you know, I haven't got anything better to do. I think I'm going to go get my blood drawn or something like that, okay? That's right. For that reason, the government insists that you collect those co-pays or deductibles. And if you're waiving co-pays or deductibles, that could be a violation of the Civil Monetary Penalties Law and the Anti-Kickback Statute unless you fit within regulatory safe harbors. The government has said that, as I mentioned earlier, they define remuneration to exclude. It generally says you can't waive co-pays or deductibles, that's remuneration, unless you waive co-pays or deductibles in the following circumstances. It can't be offered as part of any advertisement or solicitation. So you can't say, hey, come to our clinic and we will do insurance-only billing. We will waive your co-pays or deductible. Can't do that, okay? You cannot routinely waive copays or deductibles. Okay? It's not part of a marketing program. You don't routinely do it. You waive or discount only after a good faith determination that the beneficiary is in financial need or you're unable to collect after reasonable collection efforts. So it's based on financial need or your ability to collect. It's not based as a marketing gimmick. The government suggests that you should document factors such as local cost of living, the patient's income, assets and expenses, patient's family size, scope, and extent of bills to show that there really is this documented financial need. Okay? You may waive or discount government copays alternatively if you can satisfy an anti-kickback safe harbor. The anti-kickback safe harbor has a specific one that applies to hospital inpatients. If the stay is paid under the PPS. If you satisfy certain criteria, then the hospital can waive copays or deductibles. Okay? While we're talking about the waiving copays or deductibles, that's the rule that applies to government beneficiaries. What about private pay beneficiaries? These aren't implicated because it's, private pay, it's not government program beneficiaries. What if it's about your private pay patients? Can you waive the copays or deductibles for your private pay patients? Your insurance companies like that? Heck no, they don't. That's why in your contract it says that you're obligated to collect the copays and deductibles. And if you don't collect the copays and deductibles, then the payer can come after you for breach of contract or for insurance fraud or any number of things. Some of you who've been around for a while know that, 3 or 4 years ago, it was Blue Cross sent out an email telling everybody, hey, or sent out a letter telling everybody to quit waiving copays and deductibles, and that's a violation. In addition, if you're in Idaho, remember the Idaho statute? Idaho statute says, the anti-kickback statute says that you can't engage in a regular practice of waiving or rebating copays or deductibles. If you do, then you can get hit up with that $5,000 fine. All right. Well, what about writing off the bill? We're not just going to waive the copays or deductibles. We're just going to write off the whole bill. Is that okay? Well, generally it is, because if nobody's going to get billed for it, then the government's happy, right? We don't have to pay anything. That's okay by us. The insurers don't care. Yeah, if we don't have to pay anything, that's okay by us. The key, though, is to document that there's a legitimate purpose for doing it. You can do it as long as you're not doing it as an inducement in order to get other services. Now, I'll tell you what, we'll write off that bill for that Tylenol, but, we'll send you the, $100,000 bill for getting your orthopedic services done at our particular facility. So you're going to want to document that there's a legitimate purpose. It's not done to generate referrals. So it could be, for example, a resolution of a legitimate dispute or settlement of the claims. Patient comes in there and says, I think you acted improperly. You do agree to write off the bill. There's a legitimate claim. You're doing it as a patient accommodation, not to induce referrals. You'd want to document unsuccessful attempts to collect. We can't collect them anyway. We'll just write it off. Financial need or other legitimate basis. Under the civil monetary penalties law, you may waive or discount the beneficiary's bills, not just waivers of copays or deductibles, but again, as long as there's a good faith determination, the beneficiary has financial need, it's not offered as part of an advertisement, and it's not tied to other business. All right, what about prompt pay discounts? Can you offer prompt pay discounts? Well, again, if you're offering discounts to government program beneficiaries, that potentially implicates the civil monetary penalties law. If it's done for improper inducements, that could be an anti-kickback violation. So can you offer prompt pay discounts? There's no specific rule per se, but there is an advisor opinion where the government said, yeah, okay, you can go ahead and offer prompt pay discounts, at least under this particular proposed provision in the advisor opinion, if the amount of the discount relates to the avoided collection costs. So it has to bear a reasonable relationship to the cost that it would otherwise take to collect. It's like, okay, if you pay today and we don't have to come after you for collection, we're going to save X dollars because we don't have to pay the collection agency or whatever, or we don't have to pay somebody to track you down, and we will give you those cost savings. So it's the amount of the discount relates to avoided collection costs, not as a loss leader in order to get more business. It's offered to all patients for all services without regard to the patient's reason for admission, length of stay, or DOG. Yeah, we're only going to give prompt pay discounts, but only if you get your orthopedic services done here. Okay? Not advertised so as to solicit business. So it's not like, and come to us, we will give you prompt pay discounts. Can't do that. It's you notify the private payers of the program. Okay? This is one of the conditions. Why? Because the government doesn't want to see you, I guess, take down the private pay payers. And by the way, if you notify the private pay payers, they may say, fine, you can get the private pay discount, but I'll tell you what, we want to get the benefit of that too. So if we pay you sooner, then we're going to get the prompt pay discount too. And the cost can't be passed to Medicare, Medicaid, or other payers. So like if you're a critical access hospital, you're paid based on cost-based reimbursement, you can't pass along those costs to the government of that prompt pay discount. Okay? No absolute protection, but this is under the advisory opinion, probably going to be okay as long as you structure your prompt pay discount programs to fit within those guidelines. What about private payers? Well, again, the Idaho Anti-Kickback Statute prohibits regular practice of waiving copays or deductibles, okay? So if you're just waiving the prompt pay discount on copays or deductibles, that's going to create problems. If you're taking it off the whole bill, then you're probably going to be okay. You generally cannot discount copays and deductibles without violating your managed care contracts. You may adversely affect your usual and customary charges. If you're going to give these prompt pay discounts, remember, when you enter into your insurance contracts, usually you agree to pay usual and customary charges, and you represent what your usual and customary charges are. Well, if you're now offering a bunch of these prompt pay discounts or other discounts, that may reduce what your usual and customary charge is. It's not what you say it is. It's not your charge master. It's really what you're charging. If what you're really charging is this discounted rate, well, that then may affect your rate that you can get from the insurance companies, okay? All right. Well, what about self-pay discounts? This is a hot topic right now. A lot of people are saying, well, you know, with these high deductibles and the like, can we offer self-pay discounts? There's kind of this general feeling out there that I see a lot. I get this all the time. It's not uncommon to have these kind of wives' tales that are out there. You have to charge everybody the same amount. We are prohibited from charging anybody different amounts. Is that the case? Do you charge all your payers the same amount? No. Payers, third-party payers come in and negotiate with you for rates all the time, right? You negotiate separately for Blue Cross or for these other payers. You're charging all sorts of different rates. You don't have to charge everybody the same rate. That applies to self-pay patients too. If you want to do a self-pay discount, yeah, the general rule is that you can. But there are some limitations to that. Obviously, you can't charge a different rate based on you know, legally discriminatory practices, like, you know, because this person is a minority, we're going to charge them more or less. It can be discriminatory. Perhaps hospitals, there is some commentary in the old provider manual that suggests that at least hospitals that are paid under certain payment rates, that they've got to charge everybody the same rate. Okay, that's some old commentary. I haven't seen it enforced, but there is commentary in the old provider manual. But that would only apply to those hospitals that submit the cost reports. In some states, payer contracts may contain a most favored nation clause, which says that, hey, we as the insurer, you're going to give us your best rate. Well, if your self-pay rate is lower than the rate you're charging them, you're not giving them your best rate, and then that's going to automatically drop down the rate that you're going to get paid from the insurance. Now, in Idaho, we prohibit, in a lot of states, they prohibit most favored nation clauses. So your Blue Cross contract, your Regions contract can't contain a most favored nation clause. But in some states, they still allow those. And finally, the self-pay or other discounts may affect your usual and customary charges, which again, that may affect your contracting rate. Along those lines, there is a Medicare rule that basically says that a provider may not charge Medicare substantially in excess of the provider's usual charges. Well, if you're offering a significant number of discounts to your self-pay patients, that could affect this substantially in excess rule, because maybe you're charging Medicare substantially in excess of these discounted rates you're charging to all these other people. Now, granted, that doesn't occur very often because Medicare is usually the lowest payer, but it could occur in those situations, so it could potentially implicate this substantially in excess rule. Now, in commentary, the government had proposed a rule interpreting this substantially in excess rule, but they never came out with a final rule. In the commentary that's come out, they basically said, well, how do you tell what's substantially in excess? They say, well, you take your median, okay? If you're charging half your patients less than you're charging Medicare, then that's a problem. If you're charging less than half your patients less than Medicare, then you're probably going to be okay. At least that's the commentary. But just be aware, at least I've never been able to find anything that says, any authority that says that you can't have self-pay discounts, despite this general concept that's out there. You have to be aware of your contracts, and you have to be aware of the substantially in excess rule, and just be aware that it may affect your usual and customary charges. All right, what about paying the patient's premiums? You've got a patient that comes in, they need very lucrative services, whether it's an orthopedic case or something else. You could make a ton of money if they only had insurance. But wait, what about if I pay this patient's insurance premium? I pay the $5,000 for their premium, and I get to collect, $200,000 from the insurance company. That's a pretty good deal, isn't it? Can you do that? Well, if you're doing it for Medicare beneficiaries, are you offering an inducement to get the services? Potentially, yes. That could create a potential issue if it's a Medicare Part B, C, or D premiums. Okay? Now, there was a situation where the OIG, in advisory opinion, they allowed an entity, an ESRD, to go ahead and pay those premiums, and there were certain conditions that had to be satisfied. Otherwise, if it's a Medicare beneficiary, you better be careful, and you might want to look at that advisory opinion before you offer to pay those premiums. Well, what about for the health insurance exchange? This came out. A lot of providers were out there paying for the premiums for a patient to go out and purchase insurance on the health insurance exchange. Well, the government came back and said, wait a minute, we really don't like that because that really throws, messes up the actuarial tables and everything else that we did when we came up with these premiums. And although they said it does not, we are not going so far as to say that it violates the Anti-Kickback statute, they issued a letter. It was actually kind of comical because the Secretary of HHS at the time, Sebelius, actually wrote a letter and said, yeah, you can go ahead and do it. And like within a few days after, it's like the other people who really knew what was going on were saying, wait a minute, you shouldn't have said that. So they follow up with this subsequent letter that says, HHS has significant concerns with this practice because it could skew the insurance risk pool and create an unlevel playing field in the marketplaces. HHS did not expressly prohibit it, but they said HHS discourages this practice and encourages insurers to reject such third-party payments. So they're basically telling insurers, put provisions in your insurance contract that prohibit these third-party payments. And a lot of the insurers did that as a result of that. HHS intends to monitor this practice and take appropriate action if necessary. As far as I know, they haven't issued any final rules other than this caution, this warning. And because most of the insurers have put limits in that, it's probably difficult to do that. There are some situations where you can do it. For example, if you wanted to get around that, you could, like a hospital could establish a separate nonprofit foundation that allows for the payment of these premiums as long as it's not tied to a particular patient and certain other conditions are satisfied. Teresa, have you seen any update on this particular issue? Okay, so the comment was that we haven't seen anything official from it, but we are aware or have been told that there is an insurer who shall not be named who has denied payment on a claim because a third party paid for that premium. Okay. All right. Well, what about COBRA? Can you pay, patients, they're in there, they know that they're going to get laid off because of their serious ailments, and nobody told that patient about the ADA, so they're going to get laid off, and you figure, okay, well, how about if I just pay the COBRA payment for you? Can you do that? Well, again, as long as it's not paid by government programs, you're not going to have to worry about the federal statutes. And it appears that if you look at the COBRA regulations, it seems to contemplate that could be paid by third-party payers. So you might be able to do that for COBRA. Just be careful. All right. Any questions concerning those financial relationships or inducements with patients, whether they're program beneficiaries, Medicare, Medicaid patients, or other patients? Any questions, comments about that? If not, we'll move on to contracts or referral relationships or financial relationships with referring providers. So a lot of you have contracts with your providers. It could be an employment contract, independent contract, or other services agreement, a group compensation arrangement, lease for space or equipment, recruitment agreement, management services agreement, any of those financial relationships, those contracts with other healthcare providers, if they're a referral source, it's going to implicate Stark and the Anti-Kickback statute. So you want to make sure that you structure your deals to fit within regular, those safe harbors. When it comes to employees, Teresa, this gets back to your question about how does it work for hospitals and others, or really any employer. Well, there's a safe harbor under the Stark safe harbor, which says that if you've got a contract with your employee, it fits within the safe harbor as long as that contract is for identifiable services. You're paying fair market value for the services. You're not overpaying for the services. And the compensation is not based on the volume or value of referrals. Okay? You can pay the physician based on services that they personally perform because those aren't referrals. So you could pay them based on work RVUs or the number of patients they personally see or something like that. But you can't pay them, at least under this Stark safe harbor, you can't pay them based on their referrals for ancillary services. You know, we'll also give you X dollars for every injection you refer, or for every MRI that you order, or those types of things. You generally cannot do that, at least if they're within under this exception. In addition, the overall compensation, or that overall contractual arrangement, has to be commercially reasonable. So it can't be a situation where you've got this referring neurologist. You want to make sure that you're maintaining good relationships with them, so you give them this kind of sweetheart employment contract where you really don't need their services, but you just want to use it as a way to funnel money to them. Remember what happened to Toomey, that $237 million judgment? That was kind of allegedly what took place there. It's got to be commercially reasonable. Well, what about independent contractors? Well, the rules are a little bit more strict when it comes to professional services arrangements where you want to pay somebody as an independent contractor. So if you've got a physician you want to pay as an independent contractor, employment, it doesn't have to be in writing. We usually like it to be in writing because, hey, we're lawyers. We like everything in writing, right? At least the good stuff. When it comes to independent contractors, in order to fit within the safe harbor, you have to have a written agreement. It has to be signed by the parties. It has to specify the services provided. The terms have to be in place for a year. Now, you can terminate the agreement within the year, but if you terminate it within that 1 year period, you can't enter into a new agreement within that 1 year period. Why is that? Well, the government was concerned about situations where you have these series of short-term contracts that vary depending on referral patterns. Well, let's see, how much money did you send to us last month? Okay, well, we're going to cancel the old contract and we're going to give you a new contract based on your referral patterns. So you can't do that. The compensation also has to be set in advance, which means that you can't have fluctuating compensation that's determined after the fact. You've got to set your compensation formula in advance for that year-long period. It has to be consistent with fair market value. It can't be based on the volume of value of referrals. Again, you can pay them based on services they personally perform, whether it's work RVUs or number of patient visits or something like that. And it has to be commercially reasonable, okay? What about group compensation structures? Stark also applies to your group compensation structure. But remember, there's certain safe harbors that allow for referrals within the group as long as the group qualifies as a group practice under Stark. In order to qualify as a group practice under Stark, you have to satisfy certain criteria. Among other things, that compensation structure for the group members has to satisfy certain criteria. Particularly, the distribution of overhead expenses and income has to be based on a formula that's set prospectively, not retroactively. In addition, the compensation cannot be based on the volume or value of referrals for designated health services. It only applies to designated health services. So the compensation within that group can be based on the volume or value of referrals. Now, they give you a couple of safe harbors, okay? So when it comes to personal productivity formulas, you know, you want to pay eat what you kill, right? They say, fine. You can pay based on personal productivity and incident to services. So you could give that physician a part of the incident to services that are billed through that physician. Unlike hospitals, hospitals can't do that. Physician groups can. But it has to be based on the services that are performed by that physician or the incident to services. So you're basically paying them based on their own productivity or incident to services, okay? Alternatively, you can give them a share of overall profits, okay? But if you're going to give them a share of overall profits, the overall profits have to be based on groups, you know, the whole group or groups of not less than, of at least 5 physicians. So you can't carve out like little subgroups to say, well, these 2 practitioners, we're going to treat them as if they were their own little group, and they're only going to get their profits from, you know, their profits are going to be carved out separately. You can't do that. The government was concerned that if you do that, you could basically pay these 2 providers to get paid based on their referrals, right? They can share an overall, or you can create a group of at least 5 physicians and have like this subgroup and give them an overall share of the profits, including the profits from their ancillary revenues, but you can't do it for a group of less than 5. You can also pay based on any other methods that do not reflect the volume or value of designated health services. The bottom line is, if you are a group practice, you need to go back and look at your group compensation structure and make sure that it's not violating those provisions. What about for leases of space and equipment? Well, that creates a stark issue too. So if you're leasing or renting space or equipment from a referral source, or you are a referral source for the landlord, then in those situations you need to make sure that agreement structures fit within Stark's Anti-Kickback statute. Generally, it has to be a written lease signed by the parties. It has to specify the premises covered. The term is for at least 1 year. You can't modify at least the compensation terms within that 1 year period. The space lease cannot exceed that which is needed for commercially reasonable purposes. So you can't come in there and say, well, you used to see this a while ago where you'd have DME providers come in there and they would lease a closet from you and they would pay you some ungodly amount. Why? Because they wanted your referrals for the DME, right? You could lease them that, but it has to be fair market value. The deal has to be commercially reasonable. The tenant has to have exclusive use of the space or equipment. That's an important one for purposes of Stark, okay? That means that when that, if you're going to lease like a office to another referring provider, that office has to be exclusive to that individual. If you're going to lease the equipment, it has to be exclusive to that person. That means other people can't use it during the term, the period of that lease. You can't have these shared services or shared space agreements and satisfy this Stark exception. There's a separate one for timeshare arrangements that you can do that, but you need to make sure it's structured. In addition, the rent has to be set in advance, consistent with fair market value, and generally it can't be based on a percentage of referrals or income from referrals from the lessor. So it can't be a situation where the more money the lessor, or the more referrals the lessor makes to that lessee, the more money that lessor makes, because that would create an incentive for the lessor to make referrals. All right. Ownership interests. Generally, as we talked about earlier, if you've got an ownership interest in another entity, that creates a financial relationship. So if you're going to refer designated health services to that other entity, you need to make sure that you structure your deal to fit within one of the Stark safe harbors. There are certain exceptions, most notably for you who are physician groups. If you can qualify as a group practice, that will take care of it. If you have an ownership interest in the whole hospital, so, you know, people are saying, well, why in the world can these physicians open up this other hospital and have an ownership interest and make referrals over? That's because of the whole hospital exception. The utility of that whole hospital exception was limited several years ago because they basically cut it off, and it only grandfathered existing relationships, so you can't have these new facilities, these new physicians open up those hospitals. Most importantly, it's the ownership of a rural provider, that if you're located in a rural area, you're providing 75% of your services to patients from a rural area, then you can satisfy that rural provider. That allows you to have ownership interest in this other entities and make referrals over to them, whether it's an MRI center, whether it's an imaging center, whether it's a PT clinic, or whatever it is. All right, any questions about contracts with other providers? Okay, blood sugar is running low. Okay, let's talk about gifts or perks to providers or other referral sources. So these aren't necessarily contracts. You just want to give something to these referring providers. That could be, you know, gifts like thank you or appreciation gifts, free items or services like offering meals, CME, free travel, whatever, discounted items or services, payments for services that are not performed, et cetera, et cetera, et cetera. Again, anytime you've got to deal with potential referral sources, you've got to be concerned about the Anti-Kickback statute, also Idaho Anti-Kickback statute, Stark if it's their referring source for designated health services, and potentially the IRS if you're a nonprofit. Generally, when you're talking about gifts or perks to providers, there's a lower risk if the entity receiving the gift does not refer items or services payable by federal health care programs, because that's where the real risks are. But it doesn't necessarily get you out of the woods. The government has said that you may structure some kind of a transaction so that, yeah, we're only going to give you this perk for referrals for non-government payers. We're not going to give you this perk for referrals for government payers. The theory there is, hey, we can avoid the anti-kickback statute, right? But the government has said, no, we really don't like those carve-out programs, because we know if you're giving perks or offering payments for referrals for non-government business, that person's probably also going to refer the government business to you too. So really that gift is really offered to get both sides of the coin there, and therefore the government may come after you for it. So be careful about those carve-out situations. Professional courtesies. You know, does your practice offer professional courtesies to referring providers, that they can come to you and get services at a free or discounted basis? Well, is that remuneration? Yeah. Are there government payers involved? If so, then you got concerns about the Anti-Kickback statute. Stark may also have problems under the Idaho statute. Stark does have a safe harbor that applies if the practice has a formal medical staff, like a hospital. There's a written policy approved in advance. So you got to have a written policy in place if you're offering these professional courtesies. It's offered to all physicians in the service area regardless of referrals. So you're not picking and choosing based on your high dollar referrals. It's not offered to government beneficiaries unless there's a showing of financial need, and it does not violate the Anti-Kickback statute, meaning that you don't have an improper intent, that you're not doing this in order to generate referrals. Hard to prove. But even then, you've got to be concerned about the Anti-Kickback statute, the Idaho statute, and private payer contracts, which may have limits on your abilities. So, for example, maybe you have a professional courtesy policy that says that, hey, you come to us and we'll do only insurance billing for you guys. Well, that could violate any number of these things, including your private insurance company contracts. Especially beware waiving copays, deductibles, or engaging in insurance-only billing for the reasons I just talked about. Also, a lot of your practices probably have situations where you offer freebies or free services to your employees. You do it kind of as an additional employee benefit. Realize that if you're doing that, that can violate or that can be a taxable event, right? You're offering something of value to your employees. That means unless you've structured that deal, that arrangement through your employee benefit plan, then you're going to need to tax your employees for that benefit that they receive. Gain sharing or cost saving programs. As we mentioned, the general rule is that a hospital or critical access hospital can't offer inducements in order to convince physicians to reduce their ordering of medically necessary services. But the government has periodically approved those gain sharing programs. Again, the change to limit it to only medically necessary makes it more possible, so that you out there who are representing hospitals, it makes it easier to go ahead and establish these than it used to be. The government has also approved gain sharing arrangement and certain advisory opinions. If you're going to enter into those programs, you'd want to look at those advisory opinions and make sure that you minimize your risk. All right. That is a brief discussion of applying those fraud and abuse laws to common situations. Let's open it up for questions for about 5 minutes before we turn the time over to Teresa. Actually, we're going to take a break, and then we'll turn the time over to Teresa. Any questions about anything that we talked about so far? Anything that, any situations, hypotheticals? We don't want to talk about anything specific at your particular practice because we are recording. Yes, question. Oh, that's a very good question. Can you offer small gift cards to induce the people to do favorable Google reviews or something like that? And the question is, would that violate the Anti-Kickback statute? Well, let's ask this. Why are you doing it? Are you doing to induce referrals? Well, you're not necessarily induce referrals for that particular patient, but maybe induce referrals from others, right? So it could potentially implicate it. To be safe, what I would do is probably make sure that that gift card is of less than the $15 limit. There is an argument that, no, we're paying them essentially for their time and effort in going in and doing that review. I've seen it also offered not only for the Google reviews, but if you, as part of your patient portal, if you want the feedback, you'll offer some kind of benefit if they go in there and fill out a survey, something like that. I've seen those types of situations. Personally, I think that the safest thing to do is to structure those in a way so that you're not offering more than that $15 limit. I think that's just the safer thing to do. Another question or comment? Okay, so there's another question. What about a gift card drawing for signing up for the patient portal? Can you do that? Again, are you offering something of value to Medicare beneficiaries or to potential referral sources, patients? Yeah. So there is a potential for anti-kickback and maybe civil monetary penalties if they are private pay or if they are Medicare or Medicaid beneficiaries. Could also implicate the Idaho statute. this gets back to the situation. Are you paying them in offering this benefit not to get their inducements, but in order to have them complete the survey or to sign up for that inducement? It could be argued either way. I've seen it argued both ways. I think that the safer thing to do in that situation is, again, limit the benefit that you're offering to them is to less than the $15. By doing that, I think that you're going to avoid the penalty. Well, it has to be $15 per, the question is, you know, could you implicate the $75? Well, that $75 has to be aggregated of all of the thing, and no single gift card that can be more than $15. So. Okay, Kim, another question. So the question is, there's a perception apparently that some physicians, are they employed by hospitals, that the number of ancillary services are tied to their contracts. Can you do that? Could a hospital come in there and say, and you must refer a certain number of cases, ancillary services, over to our facility, labs, radiology, and the like? Well, the general rule is, you know, let's go back to the analysis. Potential anti-kickback issues if you're paying for referrals, potential Stark issues because that's a financial relationship. So then the question is, okay, have you structured the deal within a regulatory safe harbor? So yeah, under the employment safe harbor, under Stark, in order to fit within the employment safe harbor, it has to be bona fide employment, you have to pay fair market value, and it cannot be related to the volume or value of referrals. So you could not pay based on their referrals. You could not condition that on their referrals for a certain number of ancillaries. So their compensation can't be tied to the number of referrals. Their compensation can't vary with the volume or value of referrals for designated health services. Now, under, as we mentioned earlier, under 42 CFR 411.354 subsection D4, it does say, yeah. You have no idea whether I'm right or wrong. I could throw out whatever I wanted. See? Yeah. No, that specifically does say, however, that the government recognized that, look, if it doesn't make sense for you to employ a physician, only to have that physician make all the referrals over to a competing facility or a competing hospital. We're not going to require you to prohibit that. So 411.354D4 under Stark says that you can go ahead and you may condition contracts for services, so independent contractor agreements or employment services. You may require as a condition of their employment that they refer services to others within that organization, so long as you make that part of the contract. So the contract says that, hey, you're obligated to refer services, and it contains exceptions. But that limitation, that requirement only applies to the scope of the physician's services that they're providing for your facility. So if you're employing them part-time, yeah, while they're there at the facility, you can require referrals, but you can't also require them to make referrals when they're back at their practice and not on the clock for you, okay? In addition, that you can't require the referrals if the patient wants to go someplace else, or if the insurer decides where they want to go or where to send the patient, or if the physician decides that it's not in the patient's best interest. You've got to build in those exceptions, okay? So the physicians may have a perception that their compensation is tied to those referrals, but I suspect that in reality that's not the case, or at least it shouldn't be the case if it's to comply with Stark, because the compensation can't vary with the volume or value of referrals, okay, for ancillaries. Now, if it's services they personally perform, that's not a referral, so you could always compensate them based on services they personally perform. Any other questions? Yeah?
Facebook ads are designed to induce self-referral.
So Facebook ads are designed to induce self-referrals. I'm not sure I understand what you mean. I mean, you're always advertising, but you're not. Okay, so it's what you're contracted with. Who are you paying in order to get the referrals? Is it the ad agency, or you're paying Facebook? Yeah, but Facebook doesn't really control referrals per se. All you're doing is you're just marketing through Facebook. So I don't see how that implicates the anti-kickback statute. It's not going to be so tied to the anti-kickback statute that it's going to create a problem. Yeah.
Can we go back to the previous question about the patient portal?
Yeah, just so going back to the question about paying to complete the patient portal or something like that.
Right. If we offer a card to someone to use our patient portal, we're not necessarily asking them to come back for business or asking them to refer anyone else to our business. We're just needing to essentially create a more convenient way to communicate with our patients. All right,
so let me stop right there just for these people who are off-site. So the question is, well, wait a minute, if we're offering some kind of a card, a gift card or something else to these people in exchange for using our patient portal, we're not really intending to induce referrals to them or trying to get them to refer others. We just want to make sure that they're using the patient portal for reasons. So aren't you okay? Yeah, you may be okay, so long as you can establish that not one purpose of offering that gift card is to induce their referrals, but that's the standard. You're not going to fit within one of the regulatory safe harbors, okay? So the standard is, if not one purpose is to do that. And that's a hard standard to satisfy. I mean, honestly, isn't a little bit of that is you want those people to come back? And wouldn't it be really nice if they were offering? It may not be, but that's the standard, that's the test that you're going to have to satisfy. And that's why I say that it's safer to avoid that, just to limit the use to that $15. You know, and you could do it $15 per each time they do it, as long as it doesn't exceed $75 per year. Okay? That's safer. Do I think there's a huge risk? Probably not, as long as you're paying, you know, relatively minimal amounts, but why incur the risk whatsoever? All right, it's time for a break. Thank you all for your patience and listening to me for so long, droning on. We will be back about 10:30.
After the fact, the next day, an employee of mine said, well, that Medicare patient was yesterday out of his apartment, has no he's not going to get home. I have my own wallet and paid the tax. I adjusted, she didn't have permission, that violation.
Well, it's not going to be anything to cover. Did you offer something to enumeration?
Already in the development.
Yeah, it's still not done for that content reward. You're going to still within the safe harbor necessarily, but it's probably a lot of reward. Remember that you can take on a case penalty class. It has that, but it's you can offer free groups of deals as long as it's promotes patient care and
Did I tell her not to do
Patient link between the patient and caregivers. Visit mytiftregional.com today. Tift Regional Medical Center, our main campus, is located in Tifton at 901 East 18th Street. From Interstate 75, take exit 64 and follow the blue hospital signs. Thank you for your patience. Someone will be right with you. Is this an emergency? If so, please hang up and call 911. Emergency services are available at Tift Regional Medical Center in Tifton only. Cook Medical Center, a campus of Tift Regional, is located in Adel at 706 North Parish Avenue. From Interstate 75, take exit 39 and follow the blue hospital signs. Learn more at cookmedicalcenter.com. Please note that Cook Medical Center
Travel.
Okay, so we're back at the 10:30 time, so I'm going to go ahead and get started so we stay on time. I was asked to talk about a few of the common billing and coding problems that we've been seeing at the Idaho Medical Association. I'm Teresa Sorelli. So one of the biggest things, of course, is in documentation, which leads to your coding and billing that you submit to your payers. So we wanted to start here with the coding and billing and look at some of the documentation issues. One of the biggest things that we have is the copy-paste or bring forward from a previous visit. That it's okay to do it, and we're not saying don't do it, but the problem is that sometimes it brings forward information and it's not reviewed for the current data service, and it has conflicting information. And so then it looks at the payer will look at that and say, well, we really don't think this exam happened, or they may say it's a clone service, and they will discount or just reduce the service in payment. So you're looking at fighting a 99213, which is now paid at a 99212, or a 99215 is submitted, and it's going to be paid as a 99212 because it was not really submitted for the highest medical necessity that was meant to be in there, but because that copy forward reduced the service because it's now conflicting. So then there's a statement here at the bottom, and I thought it was pretty good information. The primary goal of EHR-generated documentation should be concise, history-rich notes that reflect the information gathered and are used to develop an impression, a diagnostic and or treatment plan, and a recommended follow-up. So you want to make sure that if that patient did come in for maybe a review of a fracture that they had in the previous 6 weeks, and now that fracture's been healed, but the current visit brought forward so much information that it looks like they have a new fracture. So you want to make sure that your records are reflecting what actually is going on with that patient. We also see it in the medical medication notes that are indicated in that record. They may have been, they had a new medication added at their last visit. It's not reflected in their current medication list, though. So that's an area that you have to kind of question, well, did you really review that medication list at that visit? And being relevant to the patient, it's very common that we'll see pediatric records and it says they're non-smokers. Like, okay, I wouldn't expect to have a 5-year-old smoking, or a 6-year-old female has no pregnancies. Like, okay, let's get past this point. Let's ask relevant questions for these aged patients. This is common, so it's not like it's ridiculous. It's something that we do see in a lot of records. And then the diagnosis codes for all conditions treated or considered. That's the biggest thing right now, is or considered. You don't always have the documentation indicate what your physicians or your practitioners are considering at treatment that visit, but it's okay to document those if they're putting them on a new medication or changing medication, and they had to consider all their treatments that they've had or all their conditions that they have. It's okay to indicate that in the diagnosis codes. It will increase the risk of that particular patient, and it may meet a quality measure or something like that if you're reporting measures that you could indicate that they're a high risk where you're treating several chronic conditions. And then ordering diagnostic tests. This is another area that there's a lot of failure in there in the Medicare CERT records. Pull this up higher. It'll work. Better? We'll see. Okay. The treating provider must be the ordering or diagnostic laboratory tests, X-ray tests, and other diagnostic tests.
Thank you.
It needs to indicate clearly in there why you're ordering those tests, not just run some blood work or not just check blood. What type of tests do you need to order, and maybe indicate the reason why you're ordering it if it cannot be easily inferred in there. If it could be easily inferred, you can always make a statement in your appeal, or if you're having to go back and ask for reconsideration on a claim for some reason, you can indicate, well, it's because they have this condition, we have to run this lab test. But it's easier just to say, run this series of tests, indicate what tests you want to order, and because of this condition. It's really easy just to add that little statement in there. And then that will support your medical necessity for ordering these tests. So these next slides, we're going to go into an actual record that we've recently received. So this is a real record. We've removed any patient identifying information, so you won't know, and also provider information. So they came in for abdominal pain. This is a specialist visit, so it's not just a primary care visit. She had right-sided pain. She had been in the hospital, so she had some other tests run there. On 4/17, the date of service is 4/23. And she had a CT scan that showed nothing suspicious. The physician currently is reviewing the records, and she also had urinalysis done. The patient thought that she had a small stone in her kidney and that her kidney was swollen, so that may be causing her pain. So we go through the history, we get into the review of systems, then the exam. The exam is very abbreviated here, so it removes some of the identifying information. And we get down to the bottom, previous tests. He does talk about the CT scan of the abdomen that was performed at the hospital, and he reviewed that. And his conclusion is that she probably has passed a kidney stone in between the time period that she was at the hospital and now at her visit here. Here we have a UA, though. This is current visit. There's no indication that he was ordering a UA visit or UA at this visit. He reviewed a UA, but we had no indication that he was even going to order it. And then we get into some other issues in this one here. Review of systems. This is a female. She has no family history of prostate cancer, which we couldn't figure out why. Again, we're looking at relevant issues for a particular patient. Why would we be concerned about prostate cancer for a female? And also, this patient has no male genital systems. So is there concern about her being a transgender? We have no indication about that. No indication. She came in for abdominal pain. So if there's something more that they're looking for here, we don't have that documentation here. So again, make sure your documentation is relevant for the particular patient and the visit that we're having for today. These are issues that a payer may bring out. And then the follow-up was just call if for appointment as needed. So then we're going to get into cert errors. This is the Medicare cert errors. Idaho cert errors currently, as of November of 2017, they came out with 8.4% errors in Idaho. That's pretty high. Idaho used to be one of the lowest states in the nation. We're no longer there. The national error rate is 10.2%, so 8.4% in Idaho, we're pretty high. The improper payments they're looking at, these are the common areas right here, missing physician orders for EKG. There's a missing physician order or intent to plan that lumbar MRI, clinical documentation supporting medical necessity of a brain CT scan. So this is all going back to diagnostic tests. The documentation is missing, and so they're recouping those exams, and they're probably recouping the diagnostic test also. So that's going to raise our error rate to 8.4%. And there's $55 million up there that they are projecting as improper payments. That's pretty high for Idaho. We're going to look at anti-markup. Diagnostic tests submitted when another provider performs a service. So you may be paying or contracting with another provider, and this is allowed to do these services. If you're maybe requesting like an MRI, you perform it in your office. Somebody else is contracted to read that exam. It can fit into this anti-markup claim, so you're going to have to indicate the information of how much they're charging you underneath the contract in a box 20 if it's a HCFA 1500 form, or the equivalent box or field if it's electronic. You have to indicate yes, and then the amount that they're charging you, because Medicare wants to make sure they're not paying you more than what you are paying for that service. And then in block 32, or the equivalent for electronic field, you have to indicate the name, address, and NPI of that reading physician. That way they can tell if it's a physician that's allowed to bill Medicare, they are enrolled with Medicare, because if they're not enrolled with Medicare, they're not going to allow that service. So that reading would no longer be a covered reading if it's a non-covered provider. You would have to bill the professional component and technical components on 2 separate line items. You couldn't bill the global code. And if it's on a paper claim, which is unusual anymore, but if it's on a paper claim, you would have to submit 2 separate claims, the professional one and the technical on the other. And this does not apply to diagnostic lab. It is just other types of diagnostic tests. Medicaid Healthy Connection, this is a big area, and there's a lot of recoupments that Medicaid is doing on this. One of the questions that we had come out of it is, well, I don't do it when Medicaid's our secondary payer. Like, it's still required when Medicaid secondary, tertiary, you have to have a Healthy Connection referral. And that's because the primary care doc needs to be managing that patient's treatment, and any referrals they need to be made aware of and get that referral over to the specialist. So if you are seeing Medicaid patients in any line of their insurance, make sure you get those Healthy Connection referrals. And Program Integrity will collect the money back. They consider it an easy audit because it's easy to find that there's not a Healthy Connection referral out there. And then they also apply a civil monetary penalty on top of the money that they're recouping. So that could really raise that minimal payment that you could get from Medicaid. Yes?
I can appreciate the Healthy Connection referral if some consultant tries to go directly to another consultant without letting me know, especially if I've already had that issue covered and addressed. But if I'm the one that's issuing in primary care doc the referral in the first place, clearly I'm already in the loop. What's the value of making this also do the Healthy Connection?
The value for you? To anybody? I don't know what the value would be.
I can speak to that a little bit. The primary care doc is paid a fee for that's supposed to cover a lot of the paperwork that's required of that primary care physician. So when the referral is required, it really is so that you're aware of any that patient has and whether it's medically necessary and appropriate so that you have deemed appropriate for them. So it really is your co-managing these services with the population will tend to
So the response within the room is, for those on the phone, the value of for the primary care physician or any physician is that the primary care physician is paid a monthly fee for managing those patients and their Healthy Connection referrals. Does that answer your question?
It does it from the standpoint of if I'm the one that saw the patient, I'm the one that generated the referral, I'm already actively managing them. Secondary piece of paper to say yes, filling out a secondary piece of paper to say that yes, I did send the referral in the first place seems duplicative and no additional value added. So that's why I was wondering why Medicaid makes the PCP fill out a second form that's redundant to the first form.
Or the secondary for the specialist that's billing for this patient, you wouldn't have to do a secondary referral if you've already done one. It's just when Medicare is secondary, they have another, like they have maybe Blue Cross as primary and Medicaid as secondary.
No, what I mean is that for most clinics, they have an EMR that creates and generates and faxes over referrals to the specialist clinic. And so the referral's been made, but on top of that, there's a redundant process to go into Medicaid's website to put the information in again, which is completely duplicative. When
you should be able to provide a document. Your original referral should be sufficient
So your original referral should be sufficient. You shouldn't have to go into the portal. Originally, the portal was created so that that referral number would generate and there wouldn't be a need for a paper referral. That system did not work like they initially thought it would. They did a referral gap where you didn't require one. Then they decided that they would not require that for referral through the portal. So now you have the option of doing a referral through the portal or doing a paper referral like you have, or an EMR-generated referral. The referrals can even be verbal, but they have to be documented somewhere. And they have to be in the initiating primary care physician record, and they have to be in the person, the treating physician record that receives the referral. So I would contact your provider representative then, and if that really is not, contact us at the IMA, and we will work through that process.
Thank you for bringing that to our attention.
I work for a specialty practice, and we get a lot of the doctor referrals you're talking about from the EMR, and that is not happening. And we've been told by some groups, why are you making us do this? And we've called and been told we still need the Healthy Connections actual referral.
Mm-hmm.
Yeah, so we will check on that.
Yeah.
So Teresa and I will check on that with Medicaid, and we will get back. Maybe Kim can send an email to participants.
I think there's one more question back here.
Just to second that, as another specialty office, we have been told that we have to have the Healthy Connections referral through the portal, and that a verbal or just a fax from a primary care is not sufficient for us to get paid for that service.
Okay. Thank you. Yeah. We appreciate that.
Handbook, a page that says what is required on those referrals, and as long as the office-generated referrals has those documents, we as a specialist office accept those even if they are not on the Molina Medicaid website. So maybe there's a little bit of miscommunication as to what exactly is required on the office-generated ones, but as long as it falls under that guideline that came directly from the Medicaid handbook, we as a specialty office accept those referrals from primary care physician's office that are kind of office generated. Yes.
Okay, thank you. Balance billing is another issue that is recent in our office. We had the bill that tried to go through legislation this year that did not pass. So we still do not have a balance billing law in Idaho to prevent you from balance billing a patient if they're out of network. If they're in network, of course, you're going to follow what your contract indicates you can bill the patient. But we do have one particular insurance right now that is processing EOBs for the patient differently than what they process the provider's remit. So the provider gets the remit showing an adjustment on there. You're not required to take it because you're not contracting with that particular insurance company. So you have this amount that you're allowed to bill the patient. The patient, however, receives their EOB and it shows zero amount due. So there's conflicting information between what the patient's getting and what the provider gets. And so we're working right now with the Department of Insurance on this particular insurance company because it is falling in balance billing rules that we do not have in Idaho right now. We just want to bring that one out to your attention. Just to make sure that you're watching what is posted on those EOBs of what is patient responsibility when you're not contracting versus what the patient's receiving. If they're arguing with you saying, well, mine shows I have zero balance. And that was what we had today. So it was really brief, but we gave Kim a little break.
Teresa, we have another question that was submitted online.
Okay, great.
Says, is there any OIG, CMS, or other regulatory body that enforces the copy and paste concerns? What is the best way to try and alleviate the concern with copy and paste from a compliance perspective? And then the other one is our practice must do the same EMR referral and Medicaid referral.
Okay. So the referrals must be referring to the Healthy Connection issue. But the copy-paste issue, the OIG does have some information out there on copy-paste. I believe it came out in 2015, 12 or 15, that they do have a statement that's out there on copy-paste. There's a big concern out there with it. They are watching it in many of their audits. They are going after that part of the audit also, so they will recoup money on their end. Well, thank you.
All right, thank you very much for those comments. All right, so let's say you've been sitting here and you've been thinking, oh my gosh, we've got a problem. What do we do about it? Let's talk about the report and repay rules. What are the requirements for correcting those problems? You got to be concerned about both the state and the federal statute. Let's talk about the federal statute first. As I mentioned earlier, in the wake of the Affordable Care Act, the Civil Monetary Penalties Law was revised, as well as the False Claims Act, to require repayments of overpayments. If a provider has received an overpayment, the provider must return the overpayment to the federal agency, state intermediary, or the carrier, the contractor, and notify the entity of the reason for the overpayment. So you got to return the money, and you've also got to knock on yourself. You got to explain to them why you have the overpayment. What's the deadline for doing that? You must report and repay within the later of 60 days after the overpayment is identified, or if you're paid based on a cost report basis, the date the corresponding cost report is due. Those are all set forth in new regulations that issued in February of 2016. We provided a copy of those in the written materials. You really ought to take a look at those if you've got a potential repayment situation. Now, in order to violate the False Claims Act to trigger the overpayment requirement, it has to be a knowing failure to report and repay by the deadline. What are the penalties? Well, again, you have to repay the money. In addition, you can get hit up with penalties of $11,000 to $22,000 per violation under the False Claims Act. Treble damages, you can also be subject to a key tab lawsuit. Under the Civil Monetary Penalties Law provision, there are additional penalties that can rain down upon your head. And by the way, the government is enforcing these failure to repay situations, or these reverse false claims situations, where maybe it wasn't a false claim when you submitted it, but now you know that you submitted the stuff improperly, and therefore it turns into a false claim. The government can come after you for that. They are going after providers for that. Now, it applies to overpayments. Well, what's an overpayment? An overpayment is funds a person receives or retains to which the person, after applicable reconciliation, is not entitled. For example, in the commentary that came out with the rule, they give the following examples. Payments for non-covered services. Obviously, you shouldn't keep that money. It's not, if you're not entitled to it, you shouldn't be keeping it. Payments in excess of the allowable amount. Errors and non-reimbursable expenses in a cost report. Duplicate payments. Receipt of Medicare payment when another primary payer is primary, or payments received in violation of STAR, the Anti-Kickback Statute, the Exclusion Statute, or any other conditions of payment under the regulations. That's not an exclusive list. Any situation where you've received money that you're not entitled to, then you've generally got an obligation to report and repay. How far back do you have to go? The regulations put in place a 6-year look-back period. So you don't have to go back, at least under the current regulations, you don't have to go back more than 6 years. But 6 years is still a long time and potentially a lot of money to repay. Now, it's important to note that when you're talking about the repayment obligations, the commentators, and we think the government, draws a distinction between a violation of conditions of payment and a violation of conditions of participation. A violation of a condition of payment is an overpayment, and you'll have to repay it. A violation of a condition of participation is not necessarily would not necessarily result in an overpayment obligation. A condition of payment are those things in the Medicare regulations which says, hey, before you can submit the claim, you've got to do this, that, or the other, okay? It's a condition of payment, just like it says. You got to comply with this. We only pay for this. We're only going to pay you if you do that. Those are the types of things, the violations of those things can give rise to the overpayment situation. In contrast, a condition of participation is a condition you must satisfy to participate in the Medicare program or the Medicaid program, but it's not necessarily a condition of payment. So you could violate a condition of participation without necessarily violating a condition of payment. So, for example, just because you violate the Medicare conditions of participation because, oh, I don't know, maybe you don't have the right provisions in your bylaws or something like that. In that situation, it doesn't necessarily mean that you've got an overpayment situation. If you're an ASC, if you violate the conditions of coverage, same kind of thing. If you violate state licensure obligations, you generally don't have a repayment obligation, except to the extent that if the condition of payment is you must be properly licensed in order to submit the claim, and you're not licensed, then you would have a payment obligation. A violation of HIPAA, EMTALA, OSHA, those things, those are not conditions of payment, and therefore those violations do not give rise to a repayment obligation. It's the stuff dealing with payments. Now that 60-day time period runs from when the overpayment is identified. Well, what does that mean? In the commentary, in the regulation that came out, the overpayment is identified if the person has or should have, through exercise of reasonable diligence, determined that they have received an overpayment. The key there is either you know or you should have known. So it's either actual knowledge or reckless disregard or intentional ignorance. So you can't just hide your head in the sand and think that you're going to be okay. If you're acting with reckless disregard, then you will be deemed to have knowledge, and that will trigger the obligation to go ahead and do the report and repay. You have an affirmative obligation or duty to investigate if you receive information concerning a potential overpayment. Again, if you receive one of these red flags, you need to follow up. Otherwise, you'll be deemed to have knowledge that the overpayment has occurred. For example, if you have a significant and unexplained increase in Medicare revenue, you don't know why they're paying you so much, well, maybe something's going on there. A review of your bill shows that you're using incorrect codes, and obviously that's going to trigger it. If you discover the services were rendered by an unlicensed provider, that would trigger it. If an internal or external audit discloses overpayments, or you discover that you have an anti-kickback, Stark, or civil monetary penalties law violation, those are all examples that they gave in the commentary that would put you on notice that you have an overpayment situation. That would start the time for that deadline. Now, the government says that, note that the person, that you identify the overpayment when you should have, through exercise of reasonable diligence, discovered it, even if you didn't actually discover it. So they expect you to engage in reasonable diligence. That means that they expect you to engage in some level of proactive monitoring. You can't just sit there and just refuse to do any kind of investigation, not do any monitoring, and expect to be okay. So you not only have to be reactive to investigations, but you're supposed to do some level of proactive monitoring, but they don't give you specifics on that. Now, once you've identified that overpayment, then that can start the clock, but in identifying the overpayment, it's not only identifying the facts, but it's also the amount that's at issue. The 60-day deadline begins to run when either the person completes reasonably diligent investigation. It confirms not only that you received an overpayment, but the amount of the overpayment. We were concerned that that 60-day period was going to run when you just got notice of it, but they confirmed in the commentary that no, the 60-day clock begins to run not only when you know that there's a problem, but also when you've taken steps to quantify what that problem is. That's good because sometimes it takes you a while to get the audit done, to have an outside person come in. So it's when that 60 days runs after you've completed both of those. You've identified that there's a potential problem, and you've quantified the amount that you have to repay. If there is no investigation, so you're just turning a blind eye to this stuff, the 60 days runs from the day that the person received credible information that should have triggered a reasonable investigation. Well, what is reasonable diligence? Well, in the commentary, they said, look, we'll give you time in order to, track down and find out how much of the overpayment you've got, but we're not going to give you an indefinite amount of time. They said, the government said that, look, you ought to be able to do that in 6 months. Now, 6 months is the outside limit that we're going to give you. If it takes you less than that, then you ought to be doing it sooner than that. You got to act with reasonable diligence. But they said that, generally they'll give you 6 months. So look at the timing then. So you've got up to 6 months to quantify it, and then you've got the additional 2 months, right? The 60 days in order to report and repay. So theoretically, if the circumstances justify it, you've got up to 8 months to figure it all out and do the repayment. Now that deadline for making that repayment can be told. If you decide that, oh yeah, we've got a serious problem and we think that it's a violation of the Anti-Kickback Statute, the Civil Monetary Penalties Law, so we need to self-report to the Office of Inspector General, or you think you've got a stark problem and you're going to self-report to CMS, in those situations, once you do that report, that stops the clock. It tolls the clock, okay? So you don't have to continue on. Once you get into those disclosures, then you're working through that process instead of this voluntary report and repayment rule. You can also, in some situations, the rule contemplates that, look, if you figure out you owe a ton of money and you can't repay it all at once, you may be able to enter into a repayment schedule, a repayment obligation with the carrier. When it comes to doing the repayment, you can report in one of 2 ways. One is you can go back to the carrier, like in this case Meridian, go back to them and tell them, hey, we've got a repayment situation, this is why, this is the amount, and then they will have a process that you can go through in order to do that repayment, either through a claims adjustment or through a credit balance, or they've got a process for a self-report and a refund. That's one way. By the way, that's the way you usually want to handle it if you can, because the other alternative is to go to the Office of Inspector General or CMS. Now, CMS has been pretty good on stark disclosures. They're actually good to work with. The OIG, not so much. The OIG, if you let them in, I mean, these are the fraud investigators. This is the Office of Inspector General. Once they're in there, they can look at anything that they want to look at. And who knows, what the scope of their investigation is going to be. So you've got to be very careful before you start down that path of going to the OIG. Now, there are appropriate situations where you need to, where it was a clear violation of the statute or the law, and or that you're not going to be able to do the repayment to the government because it's so much money, you can't just write out a check to the carrier. So you may have to go to the OIG. But be very, very careful before you do, because once you start down that path, you're not exactly sure where that's going to end up. So the preferred method is, hopefully you can just resolve it by going back to Meridian. Or in the case of stark violations, you just go to CMS. Meridian has a website that you can go to that has a process there through which you can do the disclosure and the report and the repayment. Now, importantly, making the disclosure and the report and repayment to Meridian, the carrier, doesn't absolve you from anti-kickback statute liability or stark law violation. The Office of Inspector General or the Department of Justice can still come after you for those other laws, the violation of the other laws. But probably you're going to be okay as long as there's no showing of gross misconduct or intentional violations. So normally we like to go to the carrier because we can avoid getting the Office of Inspector General involved. If it's a bad situation, the carrier, the contractor may report you to the OIG and or CMS. But at least, my preferred method, unless it's a clear violation, I'd go with the contractor. If it is a serious violation and you do need to go to the OIG, they have websites concerning the specific protocol for the OIG. Again, if it's OIG, it's basically and you're admitting that there is a violation of the law, which means that you're basically admitting that you can get hit up with those additional penalties. So again, it's a lot better doing that than going to jail, but make sure that you look through the issues and you feel comfortable that you really need to go that way before you just call in the OIG. Stark self-disclosure protocol, and we'll talk about that. CMS, the Office of Inspector in General doesn't enforce Stark. It's CMS that enforces Stark. I've been involved in quite a few of self-disclosures to CMS because of the Stark violations. And quite frankly, CMS in most cases willing to settle for pennies on the dollars. Stark violations can result in multi-million-dollar repayments pretty quickly, but the government, as long as it's not a flagrant, intentional violation, if it's just a technical violation, the government, I think the last study I did, it's like 2 or 3% of the potential overpayments. I had one that was like $3.6 million potential overpayment, and I think they required us to pay back $23,000 or something like that, which still seems like a lot of money, but it's a lot better than the multi-million-dollar judgment. when it comes to the OIG, they're not nearly as forgiving as CMS on those types of situations. And the penalties, if you look at the recent ones, it's usually significantly higher dollars. Okay, those are the feds. You also have an obligation, as I mentioned, under the Idaho statute. The provider must repay overpayments or claims previously found to have been obtained contrary to statute, rule, regulation, or the provider agreement. You've got an affirmative obligation to repay. What are the penalties? You can be excluded from the state program and get hit up with other penalties in addition to doing the repayment. The provider agreement, separate and apart from the regulations, when you sign that provider agreement, you're contractually bound to immediately repay any overpayments that you've received. Now, what do they mean by immediately? When I talked to Lori Stiles, who's kind of in charge of doing these types of repayments, she's told me that, well, generally when you get the letter from Medicaid telling you that you owe money back, they require a response within 15 days. Generally, they give you 60 days to repay without interest. They said that they will enter into a repayment plan for up to 12 months, but they will charge you interest. There's nothing like that in any of the statutes or the regulations. That's just kind of what their policy is in responding. So, in summary on the self-reporting, if you think you have a problem, contact your compliance officer. You might consider in appropriate situations contacting a knowledgeable attorney. Part of the reason for doing that is, one, making sure that you really do have a problem. Two, if you get the attorney involved, then you can hopefully protect your investigation under attorney-client privilege, and it may allow for a more protected investigation. Otherwise, everything that you do may be subject to scrutiny by what the government, if the government comes in there and looks at it. If you do have an obligation, then, self-report. I'm assuming most of you guys are employees. It's not, your job's important, but it's a lot better to go in and do the self-report than to face jail time by trying to hide it. Of course, in any of that, it's better to comply in the first place. So avoid those problems so you don't have to do any of the self-reporting. In order to do that, a few suggestions: make sure that you've got an effective compliance plan in place. We do a whole other presentation on the compliance issues, but if you haven't got an effective compliance plan or if you haven't updated it, you really have to bring that back out. A lot of people put the compliance plan in place just simply to protect yourself if the government ever comes in and does an investigation after the fact. Well, that doesn't give you the benefit of it. What you really want to do is have an effective compliance plan that really works so that you can avoid these problems at the front end. And by the way, if you have an effective compliance plan, it usually works to your advantage because in the non-compliant situations I've seen, it's usually situations where you're not getting enough money from the government, let alone, instead of owing money back. And if you've got an effective compliance plan, it can identify billing issues and things like that where you are not collecting everything that you're entitled to. So having an effective compliance plan can actually benefit you in the long run. All right, in closing, here are kind of my takeaways from everything that we've talked about today. You're going to go back to your office and figure out, okay, well, what do we need to do then? This is my list of action items. First of all, you need to identify any remuneration to referral sources that you guys are offering, whether that's to other providers, other facilities, vendors, government program patients, really any patients, but particularly government program patients, because those are the ones who are going to implicate the federal statutes. That would include contracts with them, whether they're employment contracts, professional services agreements, et cetera. Group compensation structures. If you represent a physician group, make sure that go back and look at that and make sure that your group compensation structure satisfies the STARC requirements. Leases for space or equipment, subsidies or loans, joint ventures or partnerships, free or discounted items or services that you may be given to referral sources or to patients, whether it's professional courtesies or other marketing plans or those things. Look at your financial policies to make sure that you're not writing off bills when you shouldn't be writing off bills, or at least that you've got the adequate documentation of financial need. You should review your relationships, not only look at your existing contracts, but to review your relationships for compliance with the statutes or exceptions. Make sure, in general, that there is no intent to induce referrals for government program business. If there is, make sure that you've structured the deal to comply with the applicable regulation. That generally requires a written contract that is current and signed by the parties. Not as important as it used to be. It used to be that you had to have a written contract, and once that contract expired, a current contract, then you were in trouble. Under the more recent STARC amendments, they actually allow holdover contracts. So even if the contract's expired, as long as you don't change the contract terms, you're not going to fall out of compliance with STARC. You need to make sure that the parties actually are complying with the terms of the contract, because sometimes you have that contract in place, people get lazy, and suddenly you find out that they're really not compliant, and suddenly that contract no longer accurately represents what's really going on. So that can create some stark issues. Make sure that it represents fair market value. If it doesn't, then you need to make sure that you adjust it so that it's fair market value. Compensation can be based on the volume or value of referrals, and the arrangement has to be commercially reasonable, meaning that there's, for legitimate reasons. You need to implement a method to track and monitor your relationships with referral sources. So make sure some way you're tracking this. You have some central way to look at these contracts so these things aren't just going out without a qualified person at your organization actually reviewing this stuff. So it may be a central repository for contracts or deals, a method to track contract termination dates, process for confirming compliance before payments go out, require review and approval by a compliance officer, attorney, or other qualified individual who knows the Stark stuff or the anti-kickback and can identify potential issues, particularly contracts, joint transactions with referral sources, benefits or perks that you're going to offer to referral sources or to patients, and your marketing or advertising. Make sure that you keep a close rein on your marketing and advertising, because those marketing people, I mean, they came out of school and they've got lots of great ideas, and a lot of those ideas are great in other industries, but they're illegal under the healthcare industry. So make sure that your marketing people understand what these limits are and you're monitoring what they're doing. Ensure your compliance policies address the fraud and abuse laws, and train your key people about these issues. That would be administration in your facility or your organization, compliance officers and committees, human resources, because they can implicate a lot of this stuff, whether it's contracts, whether they're giving away or changing compensation terms that may violate Stark or the Anti-Kickback Statute, physician relations and medical staff officers, marketing, public relations, governing board members, purchasing, accounts payable, because they can maybe be able to flag if improper payments are going out or payments are going out to physicians or referral sources without any kind of a contract in place. Make sure that these people know what these compliance issues mean. And then make sure that you document the training. If you provide training and you document the training and there's a problem down the way, the OIG may come in. You may still have to do a report and repayment, that type of stuff, but if you can show, look, we did everything we should have, and we just had a rogue employee, hey, you may still get hit up with some penalties, but you can avoid at least going to jail in those situations. You can minimize your exposure. If you think you have a problem, don't sweep it under the rug. Things really don't get better with time. Again, your job is not worth risking going to jail for this stuff. If you think you have a problem, make sure you suspend the payments or claims until it's resolved. It's one thing to submit a claim to the government when you didn't know that there was a problem. It's another thing to submit it when you actually do know that there's a problem. One is certainly a false claim and maybe a fraudulent claim and could expose you to criminal penalties. Investigate the problem per your compliance plan. Hopefully you've all got compliance plans, and make sure that you understand what those requirements are and that you comply with them. Implement an appropriate corrective action. But remember that it's not just enough to fix the problem going forward. If there's an overpayment obligation, you've got to go back and do the repayment. If in a Stark situation, you've got to collect any other amounts that were due before you can stop that period of disallowance. So prospective compliance is not enough. If a repayment is due, report and repay per the applicable law. If you are going to enter into the self-disclosure program, fine, but just be really careful when you do that. Additional resources. The Office of Inspector General has a very helpful website that contains advisory opinions, a lot of fraud and abuse training, including little videos that you can use to train your office staff about these types of deals. They've got fraud alerts. They've got compliance program guidance. So if you're a compliance officer, make sure you're very familiar with that. On our website, we've also got a bunch of free stuff, a bunch of articles, because I have no life and enjoy writing this stuff in my spare time. Some people play golf. I write client alerts. That is it. Any questions about the fraud and abuse issues, so the report and repayment issues? Any questions about it? Yes? Okay, the question is about the OIG website. So you're talking about checking the LEIE, the listed in the excluded individuals and entities on the OIG website? Yes. Is there a way to check more than 5 at once? I've not personally done this, but I have had clients who've developed macros that they can just download and they can just do a search. It'll automatically do a search. Check with your IT people. I think that they've got a process that you can actually download macros that allow you to do those, or apps that allow you to do those searches. So you don't have to go through name by name. Yeah, yeah, no worries.
My second question is regarding
Okay, so the question concerns what about when you, how do you quantify, or what do you do about quantifying the information, either the repayment? Okay, so for example, we hypothetically, let's say somebody has a provider whose license expired 4 months previous. Yeah, so how would you respond to that? Well, the first thing is you'd have to look at the conditions of payment to see whether or not the conditions of payment require that provider to be licensed, and that's most of the time, right? If it's a physician or something. I have had some situations where there may not be, the services may not need to be provided by a licensed provider, and so we've argued in that situation because no license was required to bill for that service, then we're not necessarily required to do a repayment. I don't know whether the government would agree with it. That's the theory. But usually what happens is, yeah, if you find out those services have been provided by somebody who is not licensed, then you're going to have to go back into your records and identify all the money that you've received from the federal government as a result of services provided by that unlicensed provider. Now, if that's a physician, you're probably going to have to go in there and find out not only the services they personally provided, but also the services that they ordered. If it's a nurse who can't order, different people argue different ways for calculating that. Part of it may depend on whether or not you're paid on the DRG basis, where their services just go in with everybody else. There are some ways that we have argued that you can calculate those repayments where you don't have to repay the whole amount. You just repay a portion of the DRG in that, but there isn't like definitive guidance from the government that they say you must do this, that, or the other. What we have done, particularly in the cases of nurses, when we do the repayment back, like, for example, to Meridian, we will contact them and say, you know, this is the repayment, this is how we calculated it, you know, here's the check, let us know if you disagree. And so far, knock on whatever this is, they haven't come back and asked for more money on those situations. On the expired license situations, those actually occur more frequently than you would hope or wish. You might also go in there and look too and see whether or not they can relicense retroactively, because sometimes the licensing agency will allow you to license them retroactively. You know, there's like a grace period. So it lasts, but as long as they relicense within like 90 days or something like that, that they're deemed as if it didn't lapse. Now, in that situation, I've never had to actually argue that, but I have seen the arguments that in that situation we don't have to repay because their license never really lapsed, kind of. You know, it was reinstated retroactively without any gap. I haven't seen anything officially from the government on that. But if you've got that situation, you might see whether that's an option or you can license them or relicense them retroactively. Okay. All right. Any other questions? Good question.
So to follow up on her, because licensing is a requirement of payment, condition of participation must be privileged.
Oh, good question. So the question is, licensing certainly is a condition of payment. We know that. What about under the, for example, if you're a hospital under the conditions of participation, you've got to engage in credentialing. What happens if you didn't engage in appropriate credentialing for a particular provider? Does that give rise to a repayment obligation? No, if all it is just in a condition of participation and it's not linked to a condition of payment, then I don't think in that situation that there is an obligation. It's not entirely clear. This is kind of this distinction between condition of payment and condition of participation. It's kind of been recognized by the commentators, but we haven't got a whole lot of guidance from the government on that. When you look at the commentary for the report and repayment rule, when you read it, it seems to recognize that distinction. the Supreme Court case that came down just a little while ago talking about these repayment situations. It's a little bit less clear on how they draw that distinction, but I think that it's probably the better argument that as long as it's a violation of the condition of participation, you know, the penalty is you can't participate in Medicare. It's not that, and before they do that, before they kick you out, you got to do a bunch of other stuff first, right? So it's not, I don't think that those would necessarily, I would argue that those do not trigger the repayment rule. I think you're relatively safe in taking that position until we get contrary direct regulation or announcement from the government or from a court. Yeah, how you doing? Yes, the Escobar. Escobar is the United States Supreme Court case. It was the first one that came out with and talked about these Reverse False Claims Act cases about the obligation to the affirmative obligation to repay. All right, any other questions? Okay, if that's the case, then I am going to turn you over to my very capable colleague.
We're going to talk about the
and I am actually got some other appointments, so I'm going to bow out. But if any of you have questions that I didn't answer, if you want to, feel free to go ahead and email me directly. You've got my contact information in the materials and also up there on the screen. I'd be happy to respond if you have any of those questions.
All right. For those of you who are feeling a little bit tired, don't worry. The combination of economics and legal issues usually perks people right up and gets your heart beating. Don't panic. You'll notice if you printed these out or downloaded them, you'll notice there's about 70 pages of slides left. We're not going to get through them all. What I did is, especially at the back end, I essentially put in my outline so you can just read through them later if these are issues that are important to you or you're interested in them and want to follow through. We're just not going to have enough time to get through them, and that's okay. Okay, so we're going to be talking today about the very, very basics of antitrust enforcement and how that works in the healthcare arena. We're going to go through examples so that you can see some pitfalls and find ways that you can stay safe and avoid problems. Okay, first off, who's looking at antitrust issues? To begin with, the federal agencies that are looking at them are the Department of Justice and the Federal Trade Commission. The Federal Trade Commission has a group that specifically addresses healthcare issues. The FTC has been very aggressive in reviewing mergers in healthcare and has been very skeptical about the need for mergers. And the FTC's position is that this is not in conflict with the Affordable Care Act. For them to be very aggressive in reviewing healthcare mergers, they think that their competitive issues are important enough that they should be considered as part of consolidation, which we're seeing across the country as a result of the Affordable Care Act. The Department of Justice is the agency that most people in healthcare don't want to see taking a role in their investigations, because the Department of Justice usually gets involved with major litigation and with criminal cases, and those are things that your accounting office doesn't want to see, and especially criminal investigations are not what you want to see. There's a reference on the slide to the Yates memo. This is Sally Yates, and you may remember her last year. She came to fame for disagreeing with the president about some of his immigration policies while she was the acting chair of the Department of Justice. She wrote this memo, and the big thrust of the memo is that when the Department of Justice sees antitrust violations, it's not just going to pursue those claims civilly, but they're going to pursue the claims criminally, and not just against companies, but against the specific officers and directors of those companies that were involved in the decisions. So that has ratcheted up a lot of antitrust compliance in the country, and that was the purpose of publicizing that memo. State attorneys general also get involved in antitrust enforcement, depending on where you are. attorneys general are more or less aggressive. Typically out west, other than California, attorneys general are not as aggressive in antitrust enforcement, not because they're not interested in it, but because antitrust enforcement is extremely expensive and it takes up a lot of resources. And as a result, most Western states have pretty modest antitrust compliance programs through the state attorneys general. And then finally, competitors. Competitors can be antitrust enforcers as they're watching what's going on in the market and making sure that competition is fair, and the tools that they have are the civil antitrust laws. So the goal of antitrust enforcement is to improve consumer welfare by protecting competition. The goal is to have very good competition in whatever market you're in. In the medical market, this is viewed as making sure that everybody has, that we're getting the best service at the best prices, okay? And it's not the same as protecting any particular competitor. So let's say that you work for a hospital and your hospital provides services that are high quality and low cost, and the hospital next door provides services that are low quality and a high cost, and that hospital says this isn't fair what they're doing to us, it's putting us out of business. And the enforcement agencies would say, good, they should be putting you out of business, we want you to be more efficient, we want you to be like them. And that's the purpose of competition. Competition is designed to get us better products, get us better services at lower cost. That's why we have competition. And if you fail in competition, that's what the market does. It takes out people who aren't competing effectively. Antitrust is to make sure that competition is protected and so that there aren't unfair arrangements that are preventing somebody from competing in whatever market they're in. It provides lower prices, better quality, more output, and that's what the agencies are looking for. So let's look at some of the statutes. We're going to focus on federal statutes that the agencies are looking at. Almost every state, Idaho included, has very, very similar, if not identical, statutes that apply to trade within the states, but they pretty much all parrot the federal statutes. Section 1 of the Sherman Act, and this is an agreement that unreasonably restrains commerce. And the final element is if it affects interstate or foreign commerce, and the answer is always yes. Whatever it is that you're doing, it affects interstate or foreign commerce and therefore falls under the Sherman Act. So that's typically not an issue. The big question is, do you have an agreement and does it unreasonably restrain trade? There are two general types of agreements that we're looking at when we talk about Section 1 of the Sherman Act. The first types of agreements are called horizontal agreements, and these are competitors, and so they're all sort of viewed as being on the same level, okay? These are, if you work in a specialty office and you compete with other specialty offices in the city, in the county, in the state, those are your competitors on a horizontal level, okay? And if you enter into agreements with your competitors that unreasonably restrain trade, that's a violation of Section 1 of the Sherman Act. Let me give you an example of that. The most common example of a horizontal agreement that unreasonably restrains trade is price fixing. We agree that we are going to charge X amount for this product. We agree that we're going to charge Y amount for this service. That's called a naked horizontal agreement. And for those of you who went to Catholic school, if it's naked and horizontal, it's bad, okay? And that's a violation of the Sherman Act. You can't do it and you'll get in trouble. So that's a very common example of horizontal agreement that will get you into trouble. Price fixing, agree to restrict output. These are sort of per se illegal agreements that you can enter into that will get you into trouble. The other types of agreements are vertical, okay? And this is where you go, for instance, down the supply chain. You have a manufacturer, a distributor, a wholesaler, a retailer. They're on different levels. They compete in different markets against competitors in those different markets along that supply chain. In healthcare, you have payers, you have patients, you have providers, you have these other aspects of this vertical chain where you can have agreements. A good example of this is CVS and Aetna, okay? A couple of years ago, Aetna tried to merge with Humana, and that didn't go well. We'll talk a bit about that later on. That was a big problem. Aetna and Humana, two large insurance companies, they wanted to merge. The federal government said, no, that will cause essentially you to have a monopoly in certain healthcare insurance markets. We're not going to allow it. Department of Justice won that case, and the Aetna-Humana merger fell apart, okay? Aetna decided, well, if we can't merge with somebody horizontally on our level of competition, what we'll do is we'll try vertically, okay? And so CVS and Aetna have now entered into an agreement to merge. CVS provides pharmacy benefits management services, and Aetna provides insurance. There's a slight overlap in some Medicaid work that they do, or Medicare work that they do, but probably not enough to stop the merger. The question is whether that agreement on that vertical supply chain and that vertical arrangement is going to be a problem. The Department of Justice says they're looking at it, the FTC says they're looking at it, and we'll see. Vertical agreements are typically not as problematic, okay, because if you say, okay, well, gosh, Aetna has a disagreement with CVS, and I don't like that, you can go to another insurer, you can go to another pharmacy. It's typically not an issue to have that vertical arrangement, but it can be. A good example of this is in California. A couple months ago, the California Attorney General filed a suit against Sutter Health. Sutter Health is a healthcare system. They have a lot of hospitals around the state, and the California Attorney General said, well, what they're doing is they're entering into exclusive agreements with healthcare payers, and these agreements say that you are only going to use Sutter Health hospitals, okay? And that's a problem because it's an exclusive arrangement and you're preventing other people from contracting with that payer. We'll see what happens with that, but it's the type of vertical agreement that can get you into trouble. Okay, another example is price fixing. This was a case brought about a year ago. Philadelphia Federation of Teachers, they sued pharmaceutical companies saying that they conspired to raise the price of this generic steroid. And they pointed out the fact that the price of steroids gone up 600% over the last two years. That's an example of a naked horizontal price fixing agreement, at least as alleged. We'll see what happens with it. Section 2 of the Sherman Act, this prohibits monopolization, okay? By itself, if you have a monopoly, that's not necessarily a bad thing. Okay? If you have a monopoly because you provide the best service, you provide the lowest cost, you provide the most output, that's exactly the goal of competition. And so if you have a monopoly because you're doing things the best, great. Agencies aren't going to get upset with you. They're going to applaud you. That's not a problem. The second element, though, is where you can get into trouble. It's where you exercise exclusionary conduct. Okay, and this is the example that I gave about Sutter Health is one where this California State Attorney General brought a claim both under Section 1 of the Sherman Act, well, the California equivalent of that, saying it violated that because it was an agreement that unreasonably restrained competition, and also that it's exclusionary conduct by a healthcare system that's big enough to have monopoly power to keep people out of that marketplace. The FTC thinks courts are too lax in enforcing this, and we'll see that they tend to push the boundaries in this. It's not too common to see these in healthcare, but as we see greater consolidation in healthcare markets, as you see more mergers, as you see more joint activity, group purchasing organizations, more consolidation of competitors and collaborators working together, this could see, we do anticipate that this will increase in healthcare, these types of claims. Predatory pricing is a good example of this. If you have a product that you can sell for a certain amount and you sell it below your cost, and you're the biggest and best, and you can do that and push other people out of business and then raise your costs again, that's called predatory pricing, and it's a violation of Section 2 of the Sherman Act. This doesn't usually come up in healthcare, and it usually doesn't come up at all because it's typically a terrible claim. And the reason is because courts like it when you can do this. In 2013, competitors said Amazon's lowering the price of books, and they're doing it for cheaper than we can sell them. And they went to court, and court said, great, that's good. Now we can all buy cheap books on Amazon. What a wonderful example of competition. And they said, well, what's going to happen when we all go out of business and Amazon raises book prices? And the court said, we'll worry about that down the road because I think you can just open a bookstore again when they raise their prices, and that will drag down Amazon's prices. Okay, so predatory pricing is a violation of Section 2 of the Sherman Act, but it's really hard to prove. All right, the Clayton Act is the next one, and this actually does have an application in healthcare. It comes up pretty frequently. This prohibits price discrimination, okay? So if I am selling surgical gloves to your hospital, and I'm going to sell them to you for X amount, and then I'm going to sell them to another hospital for a lower amount, you could say that's price discrimination. You can't sell that for different prices. The Robinson-Patman Act, though, has a number of exceptions. You can have discounts for volume. You can have most favored nations provisions in agreements. And importantly, very importantly for healthcare, it doesn't apply to nonprofit entities who use products or services for their own use. So in that example, if I'm selling surgical gloves to a nonprofit hospital and the nonprofit hospital is using them, not selling them on to somebody else, they're exempt from the Robinson-Patman Act, and so that claim's not going to go anywhere. Okay? Section 3 of the Clayton Act prohibits exclusive dealing arrangements, tying arrangements, requirements, contracts. Prohibit, though, where it substantially lessens competition, okay? And so these are always very, very fact-specific cases. Does it really impact competition when these happen? And as a result, while these types of cases are brought, they're not brought very frequently because they're always fact-intensive and they cost a lot of money. And a lot of times they cost more money than it's worth. And so unless it's sort of the end of your business, people usually don't bring these types of lawsuits because they are incredibly fact-intensive. Section 7 of the Clayton Act then prohibits acquiring stock or assets that may tend substantially to lessen competition. Agencies have a lot of latitude here. This is an incipiency statute, so they can prevent a merger under this statute. And there's also no time limit, so they can come after a transaction after the fact, which can be really problematic. A lot of mergers are reviewed under Section 7 of the Clayton Act by the FTC and the Department of Justice. And what we've seen, which had previously been rare, but we've seen a couple or three times over the last year or two, is that the agencies are going back on mergers that they had previously approved and said, you know what, as it turns out, in practice, this isn't working out and you have a monopoly or you're engaging in exclusionary conduct as a result of this merger, so we're going to undo the merger. And so this has caused a lot of hand-wringing, that action that they've taken. Section 8 of the Clayton Act, another antitrust provision that you really don't have to worry about. The good thing about Section 8 is while it prohibits competitors from having members of each other's boards on their boards, so if you work at company A and you have a member of your board, that member of the board can't be a member of the board of company B that you compete with, okay? The good news is there are absolutely no penalties for violating this statute, except the FTC might file a lawsuit against you and tell you to stop it, okay? Having said that, you don't want that to happen. And the reason you don't want that to happen is what happened to Apple and Google a couple of years ago. They were sued by the FTC and DOJ for violating Section 8 of the Clayton Act. And they said, look, Apple, you have a member of your board who is also a member of Google's board of directors, and you two compete, and this is a problem. Director resigned. Okay, problem solved? For that, yeah, it was resolved then. Then somebody brought a lawsuit against Apple and said, you had this guy on your board for the sole purpose of fixing prices with Google. This is a giant red flag. You had somebody from your competitor in your offices running your programs, and this person was able to fix prices between Apple and Google. And so that ultimately cost Apple about $500 million in settlement, okay? So while Section 8 itself doesn't have any penalties, it's a red flag, and plaintiffs' attorneys will often look for that as evidence of a price-fixing conspiracy. And then finally, private parties. Section 4 of the Clayton Act allows private parties to sue. You get treble damages if you win, 3 times your damages that you've incurred. So over the last year, some big cases are the mergers of Aetna and Humana, Anthem and Cigna, both of which the Department of Justice stopped. And then Attorney General Loretta Lynch explained their reasoning in going after these mergers that, if allowed to proceed, these mergers would fundamentally reshape the health insurance industry. They would leave much of the multi-trillion-dollar health industry in the hands of 3 mammoth insurance companies. And that's what the agencies are trying to prevent, and their goal is to protect consumer welfare in doing that. Section 5 of the FTC Act gives the FTC the ability to enforce antitrust laws. Now, the FTC believes, not entirely sure where they get this from, but they do, they believe that this is broader than the Sherman Act and it's broader than the Clayton Act. And so they can go after much more expansive range of what they view as anti-competitive conduct. It hasn't really been a problem. Most of their efforts to expand the Sherman and Clayton Acts have been sort of around the edges and haven't caused too much consternation, but they're constantly repeating that they don't believe they're bound by the limits of the Sherman Act and Clayton Act. So we could see broader enforcement. Okay, let's talk about some key terms in antitrust. The first key term that you need to know about is what is the market, okay? Market, it's an economic definition in antitrust, and that's the area in which you could profitably raise prices, okay? And we do this by looking at the product market and the geographic market. The first is the product market, and these are products that have a substantial degree of similarity between them. They look at a variety of factors to determine if they are reasonably interchangeable. And gasoline is a good example. Several years ago, Chevron tried to make a big push that they had Techron in their gasoline, and this was somehow better, and you know, it was a much better thing than regular gasoline. And there is an antitrust case where this was found to be just the same as other gasoline for purposes of defining the antitrust market. And then there's the geographic market, and that's your physical territory of where your market is. This is an issue where in healthcare, somebody at the FTC, some very clever attorney, came up with a way of defining the market using what he calls a hypothetical monopolist that has really changed the way we look at market structure in antitrust, and especially in healthcare. Originally, and for years and years and years, the test that you looked at in antitrust to figure out what the market was is you really looked to see if I raise prices, let's say I own a 7-Eleven, and it's not 7-Eleven, but this is actually the original example of where this came from. If I own a convenience store and I raise prices on my beer, are people going to still come to my convenience store to buy beer, or are they going to go across the street or down the block to another convenience store and buy beer there? Okay, that's the auspicious beginning of the market definition. The economic definition of a market in antitrust law was a beer sale case. It doesn't work that way in healthcare, though, because of asymmetrical information. The players in the healthcare market don't have the same information. That the healthcare provider has different information than the payer, who has different information than the patient. And as a result, that won't work by itself. If one hospital, for instance, raises its prices at the emergency room, chances are a patient's not going to know about that until the patient has already gone to the emergency room. That's been billed to the payer, and the payer has paid its portion, and then there's a dispute about the remainder, at which point the consumer says, oh, well, they raised their rates, or just their rates are really high. Because of that asymmetrical information, The FTC came up with a different test to do this, and one of the first things they look at is what they call a small but significant non-transitory increase in price, or SNP for short, okay? And that basically says, if I raise my prices some small amount, can I keep them there and get more profits? If I can, that's a good definition of the market. If not, we decrease the market size until I can, okay? So let's do an example of that. A couple of months ago, I was down in Las Vegas for an antitrust presentation, and right before I went there, I had gone to Moab to go mountain biking. And just outside of Moab, there is exactly one gas station. And that gas station at the time was charging about $5.50 a gallon for gasoline. Then I went down to Las Vegas for this antitrust lecture I was giving down there. And as I got out of the airport, one of the first intersections I drove to, there were 4 gas stations, one on each corner, all of them charging about $2 a gallon, okay? The geographic market was very different there, okay? That you can do a lot more with your prices when you're the only gas station within 40 miles, like you are if you're on the freeway outside of Moab, than you can in Clark County, Las Vegas, where you have gas stations everywhere, okay? So you'd look at that, look at the geographic market for your services, and can the hospitals reasonably raise prices if they got together in a cartel? And if not, you just keep adding hospitals until you get there. So let me give you an example. If all the gas stations in that intersection, you have 4 gas stations at an intersection in Las Vegas, they decide we're going to raise our gas prices 10 cents a gallon today, okay? What's going to be the impact of that? Well, people will just drive down the block to the next gas station and get gas there. So then you add those gas stations in, and you keep doing that until you get to a point where that person can raise prices without losing enough business that they can make a profit. And once your cartel can raise prices without losing enough business, that's your geographic market, okay? Market power, that's what you have. You have the ability to raise prices or to lower your quality without losing profitability, okay? All right. We're only going to look at this very, very quickly, and then we'll never, ever talk about this again. And you'll never need to know this ever in your life, I can almost promise you. The Herfindahl-Hirschman Index. This is what economists look at when they are determining whether there is market power, okay? And it's a scale of 0 to 10,000. If you're under 1,500, there's no market concentration. We don't have to worry about monopoly power. It's not there. 1,500 to 2,500, moderately concentrated marketplace. We might take a look at mergers or acquisitions in a marketplace in this range because it could be problematic. If it's over 2,500, that's a highly concentrated market, and your economist will tell you, you don't have to worry about this number except to know that it's a problem. And that's all you'll ever need to know about the Herfindahl-Hirschman Index, okay? The agencies use this to look at mergers when they're presented to them to determine whether a particular transaction is going to increase market concentration by a significant amount. And if it does, that's problematic, and you'll probably hear about it. Okay, so what do courts do with this, all right? What do they do with a claim that somebody has violated an antitrust law? They typically look at these on a range, on a continuum, okay? Because just because you agree with your competitor doesn't mean it's necessarily anti-competitive. Sometimes it can be good. Sometimes it can be better for competition that you agree with your competitive. Group purchasing organizations are a great example, okay? If you work at a specialty office and you can join a group purchasing organization to buy supplies for your office, you can share overhead with those other specialty offices that are involved in that group purchasing organization. You can lower costs by trying to get volume discounts on the supplies that you're buying, and that results in you being able to provide services at a lower cost, right? So that can be a good thing. On the other hand, if you just agree with your competitor that we're going to raise our rates 15%, and we're all going to charge the same rate, that's a problem, okay? And so when you do something like that, that if you have a naked horizontal agreement to fix prices, that's per se illegal, okay? On the other end of this continuum, if you have an agreement that is ancillary to a business reason that's going to improve cost, that is going to lower costs, it's going to increase quality, it's going to increase output, then the court will balance the pro-competitive and anti-competitive effects of that deal under what's called the rule of reason to determine whether it's a violation of the antitrust statutes. Okay, so we've talked about some of our per se unlawful transactions, price-fixing agreements, agreements not to compete with people. You take the west side of the valley, I'll take the east side of the valley. We won't fight over the business. We're just going to do that. Rule of reason, supply agreements, group purchasing organizations, those are all viewed under the rule of reasons. Some different mechanisms that collaborators use are joint venture, one, a way to work together to provide benefits, provide better product, provide more output, better quality by working together with a collaborator. Those are fine generally, and they look at what the agencies will look at are those three questions there. The possible restraints of trade, subordinate and collateral to a legitimate joint undertaking. In other words, is the real reason you're doing a joint venture so that you can actually get together and do something you couldn't do otherwise? Typically, no. So you're usually doing it because it's something you can't do on your own, and so it's ancillary to a legitimate joint undertaking. Is it necessary to do? Again, we're talking about things that you can't do as a business owner on your own. And finally, are they no more restrictive than necessary? And if they are not, then your joint venture is fine. What they're really trying to protect against, while joint ventures are usually not problematic, what we're trying to avoid is a cartel. This is OPEC, right, that just raises and lowers oil prices on its own without regard to competition. That's cartel, that's bad. In America, we don't allow that. We don't have anything, we can't tell the folks in the Middle East not to charge us certain amounts for oil, so we have to put up with that. But in America, that's a violation of the Sherman Act. Group purchasing organizations, agencies actually really like these. Even though they're collaborative among competitors, which usually does raise red flags, the agencies really like these because for the most part, you're going to produce efficiencies that can be passed on to the consumer, right? You're going to charge less cost to the payer. You're going to be able to provide better services as a result to patients. So the agencies are very pro group purchasing organizations. And in fact, the most recent enforcement action involving a group purchasing organization, the FTC filed a lawsuit on behalf of group purchasing organizations in a dental distribution case. There are three, I didn't know this, but apparently 85% of the distribution process for dental supplies and services goes through three companies across the country. Okay? They have 85% of the distribution market and about 60% of the entire market of dental products and services across the country. And according to the FTC, those three companies had gotten together and they had agreed that they would not negotiate at all with group purchasing organizations. They would only charge full price and they wouldn't negotiate any volume discounts with any group purchasing organizations. And the FTC filed suit and said that's a violation of Section 5 of the FTC Act. You can't do that. Now, it's interesting because for years before this, one of those companies had a policy that it wouldn't negotiate with group purchasing organizations. That's not a problem. You can do business with whoever you want to do business with. The problem is when you get competitors to agree that they're going to do the same thing that you're doing. And that's the antitrust problem with that. Okay, refusals to deal, you're not going to deal with them. That comes up in that example. Tying and bundling. I mean, this actually comes up pretty frequently in negotiations with healthcare insurance providers, or with healthcare insurers. And the issue is that a lot of hospital service, a lot of healthcare systems will negotiate exclusionary provisions, saying you're only going to provide services in, insurance in our market through our system. Okay. A lot of times there are very good reasons for that. It can be more cost-effective for you to have those types of provisions in place, but it can also be problematic if you are excluding other healthcare networks and it's impacting consumer welfare. Okay, so that can be a problem. Tying and bundling, again, in the Suter Health case, an example of this, where Suter Health said, okay, we'll negotiate with you healthcare insurer, for rates at this hospital, but you can't just enter into an agreement with us with this hospital. You've got to do this for all of our Suter Health hospitals in Northern California. And that's called tying or bundling, where you're forcing them to enter into an agreement to get something beyond what they would otherwise get. And the California Attorney General said that's a violation of the Sherman Act. Okay, so this is a little dry. When are we going to talk about health care? We're actually not, because we're out of time. Outline so that you can, if you have an interest in it, if you have concerns, questions about it, you can read through it and be able to get that. If you do have any questions, if you need to follow up, please send me an email, give me a call, talk to your attorney. Antitrust is something that I will tell you, unfortunately, there are not a lot of bright lines in antitrust. I will give you a free legal advice right now. This is generally the tone of every call I get about an antitrust issue is something like, we want to do this, can we do it? Is there antitrust risk? The answer is always, yes, there is. This is what you can do to decrease your risk, and this is what you should avoid if you don't want to increase your risk. It's the answer to every antitrust question. You just saved yourself 3 years of law school. But there aren't a lot of bright lines. It's almost everything in antitrust is a balancing test where you're looking at pro-competitive and anti-competitive effects of certain transactions. And so there are steps you can take to make things more pro-competitive, and that's good, and it will keep you out of trouble. And there are steps you can take that will make it more anti-competitive, and that's often very bad and will get you into trouble. If you have questions, though, I encourage you, if you have antitrust issues, reach out to counsel early. I have never seen an antitrust case, actual litigation matter, where the budget was less than 7 figures. They're very expensive, very time-consuming. Typically, the experts alone will be in the 7 to 8 figure range. They are incredibly expensive. You want to avoid them. It's worth spending time and effort up front to avoid antitrust litigation if you can. Address it early and don't let it become a problem. I know we didn't get very far into this, but does anybody have any questions? Okay, all right, well, you're off to lunch then. Thank you.